Item number 2, my lord. Madam, for the plaintiff, my lord, the undefended suit, my lord, has fixed at 2 p.m., my lord, for witness action, my lord.
Item number
2, my lord, in the commercial division, my lord. My lord, difficulty is that, my lord, I'm praying for time, my lord. My lord, last week there is a fire accident in the, my lord, of temple.
Pay the cost. You take adjournment.
My lord, there is a fire. My lord, there is a fire accident, my lord, in our office, my lord. We are unable to, my lord, to take out the papers, my lord. All the papers are lying there. There is no electricity, my lord.
No problem. The legalist is having crisis of money. Pay the amount.
My lord, kindly consider, my lord, there is an unfortunate situation, my lord. My lord,
for the last 3 years, you know, if the fixed matter, if you want the adjournment, this is not the new determination of me.
My lord, there is a fire accident, my lord.
This is the criteria higher fixed. If the fixed matter, you want the adjournment, the court will adjourn the matter, minimum cost of rupees 1 lakh.
My lord, kindly consider, my lord, there is a fire accident, my lord.
Yes,
We
call
don't.
the matter.
Your lordship,
there
I
is
leave to
one
comment
man mentioning.
Your lordship,
Your lordship, I need to mention regarding Kiran Baladevi, which is fixed for this court. It's part heard matter, your lordship. On the last occasion, Mr.
It is listed today. 25th. Yes. It will come on Friday list. What do you want?
To fix a date, your lordship,
Okay,
for this
come on
matter for
Friday.
hearing, and then we are on rebuttal.
Tomorrow is about it.
Your lordship, may I leave to mention?
For the other side.
Mr. Kalol Banerjee was
So if the both the
appearing.
party will come, then I will fix the matter.
I shall inform them, your lordship, whatever date your lordship, date or time your lordship fixes
You
for
do one
rebuttal.
thing on,
I shall.
Tuesday. Tuesday has to be mentioned. Mein rakho. I am fixing on Tuesday has to be mentioned. Inform the other side. If the both the party will come, then I will fix a date for hearing.
Very well, your lordship mentioning slip.
It will taken as to be mentioned on Tuesday. Inform the other side. If the both the party will come, then I will fix the date for
your lordship. We'll whatever your lordship fixes the date, we'll anyway.
No. It is facing
because we are just on rebuttal now, your lordship.
Correct. But inform the other side in presence of the both.
Very well, your lordship. I would bow down to you.
Your lordship, may I leave to mention one matter, your lordship? It's item number 44 in today's commercial division list, your lordship. This matter has been fixed on 28th January, your lordship. Till date, the matter has not been taken up.
44?
Item number 44, your lordship.
The
Commercial division. Yes, your lordship. The matter has been fixed on 28th January, your lordship. Till that matter has not been, pleadings have been completed, your lordship. There are 2 applications pending, your lordship. One for judgment on admission, that is order 12 rule 6, and your lordship. Another is rejection of plaint, your lordship. Pleadings are completed on both the application, your lordship. Kindly the matter be fixed for hearing, your lordship.
It is in the adjournments list.
Your lordship, since 28th January, this is appearing in the list. It matter has not been taken up, your lordship. Kindly give some precedent.
Okay, now today the new motion is I have taken. Then tomorrow Monday the adjourn motion will come first, and you will get the chance.
Your lordship, may kindly.
Yes, you see the Monday list, madam. You see the Monday list.
Your lordship, may I be kindly to mention one matter, my lord? The matter is pending only for filing of the compliance report, my lord. The matter appeared before Justice Mukherjee. Justice Mukherjee releases the matter as it is. It was part heard. And moreover, my lord, appeal preferred by.
Which matter?
That Madhupur property, my lord. We have filed an application under section 7 of the charitable and.
Court is not having the determination of.
It is the part heard matter, my lord.
Part heard.
Part heard.
The part heard, it will be listed on Tuesday, but next Friday.
Great.
If it is parted, it will be listed on next Friday.
My lord.
Your lordship, may I be kindly to mention CSCOM 38 of 2024, your lordship. Your lordship, an application for examining. Yes, your lordship. An examination commission was moved before lordship Vivash Patnaik, your lordship, when it was allowed on 26th March, your lordship. And therein after, senior advocate Mr. Anirudh Mitra was appointed as the advocate commissioner, your lordship. But he has denied acting as the advocate commissioner, your lordship. So new commissioner needs to be appointed, your lordship.
Who is for the other side?
Your lordship, I'm mentioning upon notice, your lordship.
Is a commercial matter?
Yes, your lordship.
Monday to be mentioned. You issue the notice to the other side. Both the party will come, then I will pass.
Grateful, your lordship.
Inform the other side.
Grateful.
Lordship, item number 28 of my lord's list today. The matter was fixed for hearing at 11:30 a.m. on 11th April, Lordship.
The number?
28 of today's commercial list, Lordship.
28. Yes.
This was fixed on 11th April at 11:30 for hearing, but the court did not preside on such date, Lordship. Today, my other side is not available in town, Lordship. May it be fixed on any date. I have spoken to
you
them.
wait. If the matter reach, you mention the matter. Otherwise, it will come on Monday's list.
I will do that. Grateful, Lordship.
my lord. My lord has not fixed the matter. It's appearing in His Lordship, the Honorable Justice Gautam Majumdar's court, my lord. My lord, the examination in cross-examination was going on of the plaintiff's witness. My lord, the returnable date is on 21st. My lord, as my learned friend said that that a fire broke out in the entire building, my lord, nothing could, no papers could be traced out. My lord, it's not till date. It's not appearing in my lord's list. It's returnable on 21st.
Okay.
I'm praying, my lord, so that the two.
Okay, come on. Let come on. 21st, we'll see to that. No problem.
I'm extremely sorry to bother your lordship once again regarding this matter. Your lordship, this notice we had informed the other side, which is the advocate on record is Mr. Guptanath Prasad. He was informed about that we are going to be mentioning. They've chosen not to be present, your lordship.
That's why I am feeling it will be listed as to be mentioned on Tuesday. Inform again. They will not come. Then I'll fix it.
Very well, your lordship.
Yes.
My lord, once I'm tendering my apology, my lord, kindly consider, my lord, the institution.
Okay, come at 2.
Grateful.
Wait, please, your lordship. To be on behalf of the petitioner.
Yes.
I am for it's on 15, my lord. Election Commission India, my lord.
Yes.
Well, the suggested issues, my lord, we have already, my lord, supplied our suggested issues, my lord, in advance to my learned friend, my lord. My lord, these are the suggested issues.
No. I will.
Notice to produce?
No,
Second again?
inspection.
But there are three
issues.
The affidavits of service also, my lord. We had, my lord, put them on notice, my lord, seeking notice to produce, my lord, discovery and inspection, my lord. My lord, those documents, my lord, are being filed by way of affidavit of service, my lord.
You are having any suggested issues?
Your lordship, may I most humbly beseech your lordships that on the last occasion, lordship was pleased to pass the order for the process of discovery and inspection. In order to comply with the order of your lordship, we need some more time because the documents, original documents are in the custody of the district election officer who is the district magistrate. And we have communicated to him in the capacity of the returning officer. So in that case, we need some more time. We will do it. I'm just praying for some more time.
When you requested for when you requested
letter. This letter has been received by the section on 8th of April. 8th of April.
Just now. And when the order was passed?
Order was passed, my lord.
7th February.
Returning officer has identified the documents, your lordship.
So
But
documents are official
but
documents.
still,
who want to inspect you?
yes,
You are appearing for?
I'm appearing for the returning officer.
Returning
Or the original, I mean to say.
Returning officer, it is your document.
No, your lordship, it is
These
with
are all,
the
my lord, official documents.
DEO, your lordship. It is always with the DEO. The custodian is the DEO, not the returning officer.
I also, my lord, have my lord's kind leave, my lord, to file, my lord, the judge's brief of documents, my lord. We have served, my lord, already copies, my lord, upon them.
So how soon you will complete?
6 weeks tomorrow.
Within a week, next week I am fixing for
Lordship,
framing of issues.
how much time do you need?
2-3 weeks the minimum.
Because it is an election petition, I cannot give
Lord,
the long
frames the issues, my lord, keeps the my lord, discovery and inspection part open, my lord. I will not stand in the way, my lord, of my learned friend, my lord, because essentially, my lord, it is not contentious, my lord, insofar as, my lord, the interest of my learned friend's client is concerned. My lord, I was humbly beseeching your lordships, my lord, if, my lord, from the next date, my lord, witness action, my lord, can commence.
That's
my
why
lord.
that's why
Because
I'm
what
asking.
I'll tell you, lordship, my lord. Now, what has been done is, my lord, few people, my lord, from that constituency, the parliamentary constituency, they have now filed a writ petition seeking declaration of election. And, my lord, here, my lord, I find, my lord, that adjournment is being sought for.
See, we are
Documents are
not parties also, and we are unaware also.
Whatever it may be, so I am giving
Yes.
1 week. You
Lordship,
expect it.
kindly-
I am framing the issues.
My lord.
I am framing the issue, and I will fix the matter for evidence.
Evidence, in fact, my lord, all the documents are official.
How many witnesses you are having?
One only, my lord.
One.
These are all official documents, my lord. I understand my learned friend will also not stand in the way, my lord, if we, my lord, tender the evidence by way of an affidavit.
Yes.
Kindly allow me 2 weeks, Your Lordship, if
Then 2 weeks, then it will go then June.
My lord, kindly, my lord,
kindly.
commence the process of witness action.
Kindly allow us some time, Your Lordship.
Section then 1st June, reopening.
My lord, may kindly, my lord, record, my lord, that I am opposing, my lord, the prayer of my learned friend, my lord, insofar
Today
as
we are on. Today we are on.
my lord, we are on, my lord,
17.
the 7th.
17. You do one thing. You complete by 28. I am giving 10 days time to you. By 28, you complete the inspection, and I am framing the issue today. And I will fix the evidence of the plaintiff witness on 6 में देखो 11 बजे 11:30 या 2 बजे खाली है.
Affidavit को बोले देगा
कितना 2 बजे 2 बजे कोई भी खाली नहीं है. Then I am fixing on 6th May at 11:30 to
Lordship.
12:30, 1 hour.
Extremely grateful.
May I humbly submit that my learned junior who is assisting me in this matter, he is occupied somewhere else. Can it be on the 7th of May instead?
7th खाली है नहीं खाली नहीं है
8th.
Grateful to you, Lord.
Suffering for the plaintiff. Suffering for the and not plaintiff petitioner. Suffering for the respond number 15. Suffering for the respond number 16. Anybody suffering for the state? No.
The state, they have, my lord remembers.
Counsel for the plaintiff has filed the three affidavit of service and judge's brief of document. Let the same be kept with the record. Counsel for the respondent number 16 press for a week time, press for 2 weeks time to inspect the original document which was lying in the custody of the district magistrate.
District magistrate, who is the district election officer.
Who is the election officer and the custodian of the document. Full stop. The plaintiff has also filed the suggested issues. Considering the submission made by the counsel for the plaintiff, this court is of the view. This is an election petition, and the election petition is to be disposed of as expeditious as possible. Accordingly, this court, considering the suggested issues and the pleadings of the parties, the following issues are framed. 1, 2, 3. Okay? 1, 2, 3. In the full stop, the respondent number 16 has given liberty to inspect the original document on or before 28th of April 2025. Full stop. Let the matter appear on 8th May 2025 at 11:30 for witness action on behalf of the plaintiff. Full stop. The plaintiff is directed to file the affidavit of evidence. You will file or directly will adduce the evidence?
But we can file the affidavit. All are official documents, my lord.
The plaintiff is directed to file the affidavit of document after to serve the affidavit of evidence of the plaintiff witness.
But that has been served already, my lord.
Oh, jo page ka panna tha.
Okay, then let the matter appear on
File the affidavit of service as well.
8 May 2025 at 11:30 for witness.
Extremely grateful to you, lordship.
Grateful, Your Lordship.
While taking leave, my lord, I will avail the opportunity of wishing my lord a very happy and prosperous Bengali New Year.
Thank you, same to you.
Grateful to you.
I'm grateful, my lord.
Lordship, I appear for the petition.
I appear on behalf of the respondent. We have not been served, firstly. And secondly, my lord, what they've been doing is, my lord, this is a classic case of, my lord, forum shopping. They've been taking time.
Classic case of
forum shopping.
Forum shopping.
Because, my lord, the matter is now before Justice Kapoor. Because after the change of determination, every day on some pretext or the other, they've been taking time. And now comes this contempt application because they don't want the matter to be heard there also. My lord, today also the item is there as number 8. My lord, we wish to, my lord, today not allow them to take any adjournment out there, and we want to move because what had happened is, my lord, this order was taken from your lordship initially, my lord, as an ex parte ad interim order, and there was a lot of suppression, my lord, out there, and we have also filed a 12-way revocation, and order 7 rule 11 is pending. So, my lord, this is the situation. My lord,
No.
they know.
That is
May I
correct,
make
but
my submission,
why
Lordship?
CC here? My order.
It is your order, Lordship. In the meantime, they have, although filed their Order 7 Rule 11 as well as revocation application, they have also taken time to file affidavits with regards the injunction application. That they have not filed. Justice Kapoor has adjourned the matter only because they have not filed their affidavits.
No, my lord, we are
They
not.
have not
Whatever
completed
it
the
may be,
pleadings.
okay, let the
Lordship would
notice be
kindly,
issued.
Lordship would kindly first see the contempt that they are doing.
Okay, whatever now he is appearing.
My lord, let them give
I
a
can
copy
serve
to us.
right
They
here,
know
right
we are
now.
contesting.
Oh, that's why I am.
Yes.
This is serve the copy. I am fixing
serving
next
it
week. I
in
am
court.
fixing next
Very
week.
Lordship would kindly hear it out once. Lordship would kindly take Lordship's order that is at page 322 of the brief.
Kindly give us a copy, please.
What are volumes? That is at page 322, Lordship.
Yes.
Lordship, the mark in question is Pankaj and Polypankaj.
Correct.
And the goods in question are hose pipes and agricultural sprayers. Lordship would kindly take the operative portion of your Lordship's order. That would be from page 326 onwards, which contains the findings and thereafter the
According to
operative
the defendants, the man, agent,
Yes.
servant, dealer, distributor, anyone claiming the defendants are restrained from passing of the artistic representation of plaintiff's registration of Pankaj deceptively and artistic selling and censoring Polypankaj. Yes.
Yes. Thereafter, your Lordship, we had tried to serve upon them on multiple occasions. We could not because they refused service. Thereafter, we took out an application for substituted service that was allowed. Lordship would kindly permit Mr. Dashgupta to continue.
Yes.
Service.
We have.
Okay, Mr. Dasgupta now he is appearing.
Yes, he is appearing.
Let the copy served.
Yes.
I am fixing next week. Let me take instructions.
In any event, if had they not appeared, Lordship would have directed me to serve upon them.
Correct.
Oh, my lord, that's not the point, my lord.
I'm anyway serving, my lord.
My lord, that's not the point. What they have done, I'll tell your lordship,
Okay.
which is now before the other court. No, my lord, this is something serious, my lord. What they do is, in the main application which was moved before your lordship, they did not annex a single invoice, which was not pointed to your lordship.
Order
Now-
16
now-
document invoice at 11th
now-
March. How can I annex it?
No. Otherwise, also, my lord, they should have some invoice showing that I was selling within jurisdiction. They didn't do that in the main application. Your lordship knows this is a commercial suit. Everything has to be disclosed. Nothing disclosed. Now, what they do is, what they forget is, they set up their own distributor and ask the own distributor to sit with my products and take pictures. Own distributor, which I'll show from that document.
Is that defenses?
Well, defenses or not, we'll see.
Yes, justify
Well, right now-
how he is
Right
selling.
now, this is item
How
8
is he
in the other
selling?
court.
All these
We'll
are
see
there.
right
All
now.
these are, all these are fine. But
Suffering
yes,
for
see
sir,
right
how,
now.
how can he sell after
Sorry
October?
for the alleged
He can't sell.
The counsel for the plaintiff has served the copy of the contempt application to the learned counsel appearing for the alleged contempt. Full stop. You will file affidavit.
Well, we'll first file affidavit in opposition to this.
Counsel for the alleged contempt. Press for time to file affidavit of compliance. Within 2 weeks.
Well, 2 weeks.
Within 2 weeks. Reply.
1 week.
Reply, if any, there to be filed within a week thereafter. List the matter on 15th May.
Very well. Grateful.
I'm in the meantime, since the order of injunction is in operation, in the meantime, they should not continue with sale. I have
That is
given
there is order.
I have
Well,
given particular.
Well, right
stand
now,
is-
the matter is
stand
being
is-
heard
sir,
as
this
item
stand is-
number
this
8.
stand is taken that I am selling his goods through
Well,
my
item number
distributor.
8.
Married before the other.
No, the only thing is, yes,
Well,
if
that's the
he continues, the order will become infructuous.
No, not in fact.
Look, item 8
Then
today.
kindly record that he said that he is not selling. That
But
should be
item
there.
8, Malad, there is no question of any recording
Item
right
eight,
now.
what is happening?
Let
Item
him
eight.
come there.
I am coming there every day. You are
Yes,
taking
yes.
item.
Come with an affidavit.
See,
Yes,
I am not.
Grateful to you. Lord.
Next week, appear for the number.
So item number 4, my lord, I appear for the plaintiff, my lord.
Yes.
My lord, there are 3 applications, GA4, GA5 and GA6, my lord.
What are the
Now,
applications?
my lord, GA4 is for examination of the defendant witness on commission, my lord. GA5 has been filed by the defendant, my lord, seeking leave to produce some additional documents. And GA6, my lord, Order 7 Rule 11 filed by the defendant, my lord. Well, I am only praying if these three applications can be taken up any day next week, my lord.
It is
Because-
completed in all applications.
No, my lord, pleadings, my lord, both the parties, my lord, I am being led by Mr. Jishnu Chaudhary and my learned friend is being led by Mr. Thakkar, my lord. We have agreed that GA4, my lord, that is the witness commission application, my lord, and the second for additional leave to disclose that will be allowed, my lord. And the order 7 rule 11 that will be treated as a preliminary issue, my lord.
That will be better.
So that is the only request, my lord. Keeps it next week, my lord. Mr. Chaudhary has not come to court as of yet, my lord. I am being
All application.
all the three, my lord.
All three, my lord.
Any day next week,
My
lord.
lord, I am appearing for the defendant, your lordship. My lord,
Yes.
am I audible, your lordship?
Yes, you are audible.
My lord, what my learned friend has suggested, your lordship, that arrangement was not understood, your lordship. My lord may kindly fix this matter any day next week. Let us come back, your lordship, and my lord may pass any necessary orders.
Sensation suffering for the plaintiff, sensation suffering for the defendant. As per the prayer made by the counsel for the respective parties, let all the application being GA4, GA5,
GA5 and GA6.
GA4, GA5 and GA6 of 2025 be placed before this court on 2nd May 2025.
Second May.
Grateful, your lordship. Grateful to your lordship.
Number 5.
My lord, your lordship. Yes, your lordship, I am appearing on behalf of the petitioner. I am being led by Mr. Choyan Gupta in this matter. He is appearing online.
Who filed GA2? You.
My application is GA2, my lord, for consolidation of the suit. But my lord, what I find, my lord, is that so far as GA1 is concerned, I have applied for vacating of that order also. Kindly have a look at that order once.
Which order?
The order, my lord, which is subsisting in, kindly, my lord, take GA2. GA2, page 15.
GA2 under section 10.
Section 10, my lord, my junior, I believe, my lord, was trying to impress upon the court that section 10, so that the two suits should be clubbed. But, my lord, when I went through the papers and the pleadings, my lord, I found, my lord, subject to what your lordship find, my lord, that this order needs to be tested. If this is tested, my lord, then obviously section 10 is for my learned friend. It is his suit. If he wants both suits to be tried together, I can also come. But kindly see the order at page 15. 1-5.
Yes.
My lord, kindly see the situation. This was an application, my lord, in a money suit, simpliciter money suit, where they, my lord, prayed for an order of attachment before judgment. Now, the day it was moved, kindly, my lord, see, plaint presented is admitted subject to scrutiny. That is the day that plaint was presented, 21st January 2021. Leave under clause 12 of the latest patent, order to rule 2 is granted. In view of the seeking urgent relief by way of interim application, leave under 12A is granted. So 3 leaves are granted. Now, in a suit for recovery of money lent and advance, the plaintiff seeks interim protection. Very good. Learned advocate appearing for the plaintiff submits that the plaintiff lent and advanced the principal sum of 1.95 crores to the defendant. The defendant repaid a sum of rupees 45 lakhs on account of principal. The defendant is due to repay the balance principal amount of 1.50 crores and the outstanding agreed interest thereon. He submits that unless the defendant is restrained from withdrawing any amount from the bank account mentioned in prayer A of the application, the plaintiff will not find any asset of the defendant to execute the eventual decree that may be passed in the suit. This is all. The defendant is represented. So I was there on that day. Learned advocate appearing for the defendant submits that a copy of the application may be served on the defendant and he may be permitted to contest the application. In the circumstances, the plaintiff having a prima facie case, where is the question? If I may ask, one line, that this is the prima facie case I find. And for that reason, Millard, although the defendant is present, he is not being served, I don't need to hear him. In view of the plaintiff a prima facie case when the balance in favor of the plaintiff and unless an order is passed, there is a likelihood of the plaintiff being prejudiced, it would be appropriate to pass an order of injunction in terms of prayer B. Then below this injunction. And this is of 21 and my vacating application is also the very next month.
What is the application number?
That is below
One.
GA2, which is your lordship is here.
This is this one. Okay.
Now, Millard, this order, Millard, I have applied for vacating. This order, Millard, on the face of it shows that it has been passed in violation of the principles of natural justice. Number one. Number two, Millard, I do not say that the court does not have the power to grant an ex parte ad interim injunction. But if the defendant is present and wants to represent, Millard, no order could have been passed without hearing him. No court does it, Millard, but the court felt that no, I do not hear him. There are enough materials before me to come to a conclusion that an injunction is required. Then, Millard, at least if I have a right of appeal against that order, I must know what is the material on the basis of which the court came to the conclusion that there is a prima facie case and balance of convenience. Otherwise, Millard, my right to appeal also goes. If I want to go before the court, I can go before the court and say that the order doesn't have a reason. That could have been. But Millard, the ground of appeal is, I have agreed by the ground which the court has seconded that this ground on the basis of which ought not to have been held, therefore that. So if I am not apprised of the grounds on the basis of which an injunction is passed, effectively my right to appeal also goes. That's the third point. And the fourth point is this, Millard, it is well established that so far as attachment before judgment is concerned, it cannot be passed at an ex parte stage or at an ad interim stage. It has to be upon show cause being shown or failing to show cause. Because this order is in the nature of an attachment. The order of attachment could not have been passed.
Yes.
Now, so far as the injunction is concerned, I believe, Millard, the learned judge proceeded on the basis when he says that it has a prima facie case and the balance of convenience, Millard. With respect, Millard, the suit is not the subject matter, number one. And number two is this, Millard, that so far as injunction is concerned, my learned friend ought to have, I'm sorry, Millard, the court ought to have at least recorded what is the prima facie case. Millard, Order 38, Rule 5 or Order 39, 1 and 2, Clause B, Millard, courts have in umpteen number of cases held that it is a right in a money suit, you don't get an injunction eo instanti. Just because somebody has lent an advance money, and here is a case, Millard, where I have repaid the money. Now, what was not, now that, Millard, the principles of natural justice has been extended to say that merely by saying violation won't do, you will have to show, had you been given an opportunity, what would you have shown? Millard, had I been given an opportunity on that date, Millard, I could have shown to your lordship that there is a previous suit between the same parties pending in the City Civil Court of Calcutta. Now, Millard, if I may ask myself this question, if an issue...
Who has filed the suit?
My Prabha Surana has filed the suit. That suit, Millard, your lordship will find.
Yes, yes, I remember.
Yes. Mother and two daughters. So, Millard, if this issue is sub judice, Millard, which court? So, Millard, the issue is sub judice before a forum. The plaintiff suppresses that fact or doesn't refer to that fact, and he comes before this court and wants an ex parte order of injunction. And not a single line pleaded as to what is the urgency. And the court also doesn't find any urgency.
Yes.
So, Millard, my first prayer in this GA2 is for stay. That is on section 10, which Millard, my learned junior. 12A, Millard, at that point of time, the law was, but now it is more or it's a commercial dispute. I am taking interest, it's not a commercial. Then Millard, C is what I am trying to.
Vacating.
গাড়িতে পড়ে গেছে এত দেখ ওটা না আছে
Yes. That's all.
আরে চালাও
ए फैन चलो एसी नहीं चलता
So, my lord, until and unless my learned friend on the face of it, my lord, injunction application to law.
Volume 2.
My lord, kindly now take the injunction application. The claim. ওদের injunction application টা দাও।
123. 123.
Milord, kindly, Milord, come to page 123. Milord, after the plaint, because your lordship today is not concerned with the correctness in the plaint, is the averments on the basis of which whether this order could have been passed.
Page 123.
Page 123, the application starts.
Volume 2.
Volume 2. Volume 2 number volume 2.
Yeah.
Your lordship has brought it. Lordship will find this is the Milord, urgency pleaded. I couldn't find any urgency. Apprehensive with respect to non-payment of the amount, and upon inquiry, the petitioner has come to know that the respondent has defaulted in some cases.
Which page you are reading?
Page 131. His case, Milord, is briefly stated. He has given 1.5 crore. I have paid him back. Balance I am not paying. And the basis of the injunction is paragraph 14 onwards, Milord. Non-payment of amount, and he has made an inquiry and has come to know that the respondent has defaulted in some cases and various other money recovery proceedings are pending against him. The respondent may dispose of all the property and belongings in order to evade the loan. This can be an allegation. Now, section 14 has been affirmed as true to knowledge. Paragraph 14, I'm sorry. Page 138.
Yes.
No particulars given. Which recovery of proceedings? So he has knowledge, but he chose not to come before to tell the court that these are the proceedings which are pending.
Yes.
Then 15 also true to knowledge. Kindly see. Bank account is there. The respondent is contemplating to siphon of all monies lying in the above account to the prejudice of the petitioner, trying to evade any connection with the petitioner. Under such, there is an imminent threat claim responding in order to defeat the petitioner may dispose of taking out an application such and such.
Yes.
Then, my lord, my lord, thereafter, my lord, your lordship will find, despite received so and so, the conduct of the respondent completely denying the transaction reveals the intention. Eminent receiver is necessary for protection, trying to evade payment. Respondent is not paying the dues. State that to protect the interest should be called upon to furnish security. Fails to show cause. These are the necessary pleadings of Order 38. So, my lord, apart from paragraph 14. And, my lord, the allegation of receiver and to the statutory pleadings, this finding of the learned judge that there is a prima facie case, The prima facie case that can only surface is that a loan was taken. Nothing more than that. So if a loan has been taken and the plaintiff says it's a loan, that is not a ground for granting an order of injunction or attachment. These two persons and Millard are carrying on businesses. Millard. This man has all of a sudden come and obtained an order of injunction, suppressing the fact that there is already a previous suit pending between the two families who carry on business in money lending. There are previous transactions also. So, Millard, if I may ask myself this question, that do I not get an opportunity to at least meet this? Or the court finds that he has made out such a brilliant case that he is entered into an agreement for sale with third parties, or he is trying to leave India, move outside jurisdiction. So, Millard, the courts, Millard, this is one judgment, Millard. There are umpteen number of judgments, but Millard, your lordship will find the decision of Premchand Mundra is the base of all the judgments. So, Premchand Mundra, Millard, very clearly says that just because you have lent money and you have filed a suit does not entitle to an order of attachment or injunction, which is Millard, AIR 1951 Calcutta, page 156.
AIR
1951 Calcutta, page 156.
Yes.
Millard, paragraph 10. I'm handing up my copy. Paragraph 10, Millard, the guidelines have been laid out. Until date, this law is being followed whenever it comes to a question of injunction in money suits and attachment. Paragraph 10. Last week. Okay, 17. Huh? That's how it looks. Sorry.
Yes.
So that is Millard. Now, Millard, none of them, Millard, your lordship will find is there. There is no. If they go by the logic that they are entitled to an order under Order 38 Rule 5, Millard, then Order 38 Rule 5, if your lordship now has, Millard, I'm sorry. Millard, I lordship did not follow. Where at any stage the court is satisfied by affidavit or otherwise.
Correct.
So, Millard, the satisfaction has to be reflected in the order. That on the basis of these facts, I am satisfied that you are trying to defeat a degree.
Now, nowadays, You can also be the other side. They are taking the aid of the Rahul Shaha. So it can be taken as Order 39, Rule 1 and 2, or as a 151 application, and the court can pass. Now,
Can be.
yes,
Can be. Rahul Shah also refers to 51 Calcutta.
correct.
Now the thing is this, Willard. If I'm not wrong, Rahul Shah takes recourse to the fact that if we have filed a money suit, most cases it is found that at the time of execution of the decree there is nothing. So therefore, at an
151
interim
can.
stage, you can
151 can involve.
you can use 151 and can direct them to give a affidavit of assets.
Correct.
So that I know that I am protected to the extent that this affidavit is there. But this is not in terms of Rahul Shah.
Yes, yes.
I can understand, Millard, the court can come and say that, look, it appears from A, B, C evidence that you are trying to defeat.
That is different, yes.
So I am calling upon you. So, Millard, that this satisfaction has to be there, has to be satisfied by affidavit. Millard, this satisfaction with respect, Millard, is not reflected in the impute order.
Yes.
And Millard, if they go by the principles of injunction, Millard, prima facie case, balance of convenience,
Then
and
the ground, sir.
then Millard, the very simple thing is this, Millard, in a money claim, there cannot be an injunction because compensation in relief is an adequate relief. One of the principles of injunction is that money cannot compensate me. In a money claim, where you are saying that the defendant is not being able to pay and is running away, so that means he doesn't have the means to pay. Then why are you attaching his bank account? Why don't you attach his property? Why don't you call upon him to file an affidavit of assets disclosing what are the means to satisfy? And give him an opportunity to file an affidavit to meet it. The defendant is standing, he is not being served, and the court says, I find a prima facie case without Millard even trying to go into the issue as to what this prima facie case is.
Yes.
Those would be.
Thank you.
You want an opposition reply?
The opposition
Yes.
next
No, the GA2 GA2 vacating.
But if your lordship kindly sees the application, this is everything into one. Revocation of clause 12, vacating section 10, everything into one. Now I'll address one at a time, because everything is jumbled up here.
Now I think Mr.
I've only taken one.
Only taking one application regarding vacating.
Yes, that the order needs to be vacated.
There's nothing else which you're pressing.
12A, Millard, I told you that time.
12A is not pressing, is not arguing on that on the point, and section 10 automatically.
Section 10?
Section 10 is also not arguing.
Not
It's only with regard to the
Then I'll only need to answer on the vacating.
vacating.
If your lordship kindly sees, vacating would be under the principles of Order 39 Rule 4. Kindly takes the Order 39 Rule 4 once, Your lordship has seen it umpteen number of times, but for my satisfaction, if your lordship kindly takes it once. Order for injunction may be discharged, varied, or set aside. Has your lordship got it?
Yes.
Any order of injunction may be discharged or varied or set aside by the court on application made thereto by any party dissatisfied with such order, provided that if an application for temporary injunction or in any affidavit supporting such application, a party knowingly has made a false or misleading statement. This is one which has to be proved.
Correct.
In relation to a material particular, kindly marks this,
Correct.
material particular, and the injunction was granted without giving notice to the opposite party, which is the case here, the court shall vacate the injunction unless for reasons to be recorded considers it that it is not necessary to do so in the interest of justice. So even if there is misleading, your lordship can continue the injunction order provided there is reasons to do that. So here we are at a stage where the only window, in my humble understanding, subject to correction by your lordship, would be that if there is any misleading statement or material particular. Now, what is the case which they have sought to argue before your lordship? That there was a prior suit. Kindly seize the plaint in the prior suit.
No, first
you can. You said that I have
the submission. No case has been made out, that is one. Second is, that there is a prior suit which, if given notice, they could have come up and told to your lordship, told to this honorable. These are the two arguments given.
First thing is kindly come to the impugn order.
Yes.
Yes, this court has recorded your submissions.
Yes.
And defendant was present.
Yes.
But no notice was
No
issued.
notice was issued.
So that is covered.
That is covered. That is covered.
No. Then the prima facie case, where is the reason on that?
Yes. So that, in my humble submission, is an appealable point, not a point seeking vacating. This, if an appeal could be preferred, this possibly
For
could have
the
been
ad
argued.
interim injunction,
Yes.
there are three ways. That is settled by this court.
Yes, but if
That
the
is settled by
defendant
this
chooses
court,
one way,
settled by this court, either he has to prefer an appeal, or he has to file an vacating application, or has to
objection, written objection, or affidavit in opposition. So the defendant has availed the second line, which is available to them, which is paying for vacating. Now, in what circumstances the vacating can be granted? It's not now your lordship is not sitting in appeal over this order. Your lordship would see whether this order is falling foul with the principles under Order 39 Rule 4 for it to be vacated.
Correct.
So whether the reasons have been recorded or not, that, in my humble understanding, subject to my lord testing it, of course, is not a point which is available in an Order 39 Rule 4. Okay. That may be a point available in appeal.
Okay.
But when the defendant chooses this avenue to file a vacating, perhaps, my lord, they have to, my lord, come within the four corners of Order 39 Rule 4.
Yes.
Now, my lord, in Order 39 Rule 4,
yes,
your lordship would kindly consider that whether the injunction was obtained by misleading statement or by making a false statement, knowingly. These are the two things which needs to be, my lord, established. Now, your lordship would kindly see one of the submissions of my learned senior friend was that if notice could have been given, then we could have submitted that there's a prior suit between the same. That is one. I'll deal with the other point later. Kindly sees what is the other suit which has been referred to. Kindly see the plaint in that suit. Your lordship will kindly have a look at the second volume, page 113. And kindly keeps the cause title of this suit side by side.
113.
113.
Yes.
Kindly sees the cause title in that plaint before the city civil court at 113, and kindly sees the cause title in this suit.
Yes.
This is a suit where Asterix Enterprise Private Limited, which is an NBFC, has filed against Sunil Kishan Punwani. That is one. That suit is Anita Sunil Punwani, Anisha Sunil Punwani, Aisha Punwani. They are daughters of Sunil Punwani. They are the plaintiffs. Kindly see who is the defendant. There is sole defendant, which is Prabha Surana. The three other, there are three others who are Asterix, Shanti Surana, Sunil Kishan Punwani, who are pro forma defendants. No claim is made against Asterix. A. B. This is not a suit. Your lordship will kindly see the prayers once. Page 120, your lordship will find the claims in the suit. Decree as pleaded in paragraph 20. Page 120, your lordship will find the claims in that suit.
Yes.
As pleaded in paragraph 20, decree. Kindly sees paragraph 20, which is page 119. The defendant number 1 is liable to pay to the plaintiffs sum of rupees such and such, 96. Now, and also the cause of action at paragraph 21 is when the defendant number failed to pay the amount.
Yes.
Now, your lordship will kindly see there is nothing against, there is no claim against Asterix, which is the plaintiff in this suit. A. B. That this is not a loan which Asterix had given to Sunil Kishan Punwani, the subject matter of this suit. May I draw your lordship's attention from page 114, paragraph 1 of the plaint. Defendant number 1 approached the plaintiff number 1 and requested to grant a loan at such and such. Then kindly sees page 115, paragraph 3. It talks about negotiation between the defendant number 1 and the plaintiff. Paragraph 3 at page 115. I'm sorry, Bullet. Page 115, paragraph 3.
Yes.
This is the negotiation between the plaintiff and the defendant number 1, pursuant to which amount would be made over by as and by way of loan, which was accepted. So this, my lord, is the subject matter of the suit before the City Civil Court at Calcutta. Now the plaintiff has filed this suit for a money lent and advanced by an NBFC to a different individual who is not a plaintiff.
What has happened to your GA1?
G1 is pending. They have not yet filed their opposition, despite direction on the first day.
Mr. Dutt,
My lord.
there is a GA1, their injunction application.
Yes.
Correct. You have filed for vacating the and you have not filed the opposition in that.
No, I filed. No. Opposition. No. Service করেছো?
No.
ये GA1 में affidavit है देखो.
No.
GA1 में.
কবে affirm করেছো? It's lying affirmed 5th of April 2021. No, Millard, it's not been filed with the court.
No, served.
No, not served.
So you have filed this vacating application. If suppose the court vacate also, then the court has to hear the injunction application. Correct. So what I propose, let the both application be heard together.
I have no objection to that because if he goes by order 39 rule 4, he fails. He has to satisfy under order 39.
That's what I'm telling. That's what I'm telling. If suppose the court vacate that, again the 39 rule 1 and 2 has
the
to
right to pass again an order of injunction.
So that can be done.
Yes. Then could we come back by using an affidavit in that? Affidavit in reply to that. Not yet served.
How soon you will file affidavit?
I have filed. Millard, my objection is lying affirmed with me from 5th of April 2021.
But we had 4 years.
Due to this COVID, you have not served.
I don't know, Millard. Why?
Okay, you served it. How soon you will file affidavit in reply?
2 weeks.
A small thing.
I don't know. It's 2-volume affidavit. I do not know. I have seen from. It's a 2-volume affidavit. Well, we'll have to take instructions also.
Census suffering for the plaintiff, census suffering for the defendant. Full stop. The plaintiff has filed an application being GA1 of 2021 praying for interim order. By an order dated 21st of January 2021, this court has granted an interim injunction. Now the defendant entered appearance and filed an application being GA2 of 2021 praying for vacating the interim order. The defendant has also filed affidavit in opposition in connection with GA1 of 2021 after serving the copy to the learned counsel for the plaintiff. Counsel for the plaintiff prays for 2 weeks time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks from date. This court is of the view the both applications being GA1 of 2021 and GA2 of
Millard, I believe Millard, my learned friend will take instructions.
Okay. Reply is also
Reply is also been filed.
Reply also filed.
I think Millard, obviously. Why will you make us
reply here?
GA2 or literature.
one of these is GA2 GA2 page.
GA2 আছে
GA1 and GA2 both reply.
Yeah, it is GA1.
And this is GA2. I'll serve them. If I have a copy, I'll serve them. So, Millard, that direction need not be filed.
It's a change brief, but we have affidavits in GA2. But we don't have anything in GA1 except the
reply is here. Yes, the reply.
Find the reply also. No, I'm sorry, Mulad. It's not with us, Mulad. I'm really sorry.
I'll serve them a copy. I'll see it.
So I am not recording.
No.
क्या बोला? So suffering for the plaintiff and the plaintiff has filed an application.
I'm sorry, Mulad. Kindly do not take
for an interim injunction and by an order dated itna. The defendant has filed an application being GA2 for vacating the interim order. बोले बाकी सब काट दो. It is fine from the record. Pleadings in connection with both the applications has been completed and both the application is to be heard together. Let the matter appear. Date दो. Commercial है ना. 29th में देखो टाइम है कुछ. 29th April. Now you will not go till long day. 2 बजे 1 बजे कुछ नहीं है. 29th April under the heading adjourn motion at the top.
Oh, bless. Well, I'll sub my learned friend with. Hey, cheeky dear brother, huh?
Both the opposition and the blocking.
See if it reply is not filed in the record, then you sub.
Then we'll reconstitute the reply.
ऐसे देखे नहीं किंतु opposite.
I'm really sorry, Milord.
It's okay.
He did not know. He is also chair. I have also come.
No, last occasion, Mr. He has
Yes,
argued.
Milord. I told him. I told him that in his suit he would be prejudiced if I get a degree earlier. He would be so. It is for him to come and say that stay the other suit. Why are you going and asking for stay of your other suit?
Yes.
Grateful.
Grateful.
Hello.
This matter, my lord, item number 6, IP of the plaintiff, my lord. This is a.
I'm for the respondent, my lord. I don't have a counsel right now, my lord.
Huh?
I don't have a counsel, my lord. I'm praying for 2 weeks accommodation.
You don't have a counsel?
My lord, just is the last name, my lord.
What is the?
My lord, the last name, my lord.
That is 16th. What has happened after this? 16th August 2022. After that?
My lord, 16th August. 15th August is the last one. Where's the last one? My lord, this is I'm in a bit of a precarious position as well, my lord. This is a changed brief. My lord, to the best of my instructions, my lord, written notes of submissions have not been filed, my lord.
What is the GA1? Interim?
The GA1 was my interim application, my lord. That interim order was granted, my lord. That was vacated, my lord. From what the orders, my lord, tell me.
Vacated?
Non-compliance with Order 39, Rule 3, my lord, by the erstwhile advocates on record, my lord. Which is why, my lord, that was vacated. My lord, kindly takes the order of 2nd of March 2021.
On compliance of orders and so on.
Yes, ma'am.
So thereafter no interim order till now?
No, my lord.
So in this GA1, the affidavits have completed?
Affidavits are completed.
My lord, there's also GA2, my lord. That's an application, my lord. I
Reimposition?
believe, my lord, for attachment.
Attachment? By the plaintiff?
Yes, my lord. My application.
Your application?
Yes, my lord. My application, my lord.
GA2 है क्या वहाँ में? नहीं है. GA2 is not here. It is also not in the list. List में है लेकिन record नहीं है.
I believe it's there in the list, my lord.
Yes, but it record is not there. In that pleadings completed?
My lord, pleading completed.
GA2 also?
My lord, and we went into appeal. Appeal court has verified the order to that extent, my lord. Right now, I'm a little handicapped. Don't have a counsel, my lord.
My lord, I do not have any instructions as to the appeal, my lord. This is a change brief, my lord.
So do one thing, you
Yes,
go through that. I am fixing on next after 2 weeks. So come ready with all affidavits and all these things.
We'll do that, my lord. I'm grateful. I'm very grateful.
So and so appearing for the plaintiff, so and so appearing for the defendant. The plaintiff has filed an application, filed 2 applications being GA1 of 2021 and GA2 of
GA2, my lord, of
2 of 2022.
22, my lord.
2022. It is submitted that pleadings in both the applications being completed and matter is ready for hearing. In view of the above,
My lord, may I have my lord's kind leave, my lord.
In view of the above, let both the application be placed before this court on 6th May 2025 for under the heading adjourn motion. Next.
Item number 7, GA5 is my application. It's an application by the defendant, my lord, challenging the report of the learned special referee by which mean profit was assessed. Now, my lord, will see from the last order, direction were passed for
filing of affidavits, and my lord had also, my lord, asked the parties to settle the matter if possible. Now, there were some informal talks, but nothing concrete happened because, my lord, the defendant, which is a company, the director Shormisha Chaudhary had undergone a spinal cord operation in March. So, my lord, she's bedridden and her son is right now in Dubai. Now, I don't want to take this as a ploy to keep the application pending, my lord. I am ready to proceed with the application, but they have not yet filed any affidavit. This is the position that we stand today.
Lordship direction, I have given the offer because the special referee assessed the mean profit to the tune of 1 crore 3 lakhs. In reply, I have given them communication pursuant to your Lordship direction that 70 lakhs, if it is assessed, we are agreeable, provided if they settle the matter. Now, since we have paid the 50,000 remuneration, if a Lordship...
What is the eviction suit?
Eviction suit, decree of eviction already passed. They have received the possession of the suit property.
And in the decree, my lord, 24 lakhs is the amount the due and payable apart from the main profit, my lord. Areas of rent, which they have not paid.
That execution is pending, my lord.
Plea, my lord, that after all, this is a private limited company. Somebody has to take the responsibility, my lord.
No, that's why I said I don't want to take this as a ground for adjournment.
My lord, let them press it.
So you're not ready to pay the 70?
My lord, right now, my client is bedridden. As I understand, the company does not have money. She has to procure the money from her son, who's in Dubai, my lord. So, my lord, she being bedridden, she had incurred considerable expenses for a surgery in March, my lord. So that's the reason, my lord, and there's lack of communication. My lord understands that. I don't want to use this as a ground to not press my application. If my lord so permits, they have not yet used an affidavit in opposition. If they don't want to, I can proceed with the application.
Will file affidavit?
No, I do not like to file the affidavit, my lord. If Lordship feels that there should be a fresh assessment, Lordship can remand back to the special referee because I have paid 50,000 remuneration pursuant to Lordship's direction, my lord. So let him decide upon giving the opportunity to put the party.
I'll indicate, my lord. Yes, my lord.
If after all, suppose I satisfied your ground, it has to be set aside and again remanded. But anyhow,
again, it has to be assessed.
Has to be assessed.
Yes, absolutely.
You have to pay some amount.
Yes, absolutely.
Correct.
Absolutely.
Now they are assessing 75, 74, 70.
My lord, I have given in writing letter to them, my lord.
May I make this suggestion, my lord, to my learned friend also? If they want to use an affidavit, kindly extends the time, keeps it after 3-4 weeks, my lord. In the meantime, if we are unable to settle, we'll come back and inform my lord.
No, why I'm telling, if at all the court set aside that recall or whatever
it should be only one meeting held without notice to parties.
Correct.
That's why
Correct.
perhaps no affidavit has come.
Anyhow, the assessment has
Yes. I absolutely agree. I have already informed this to the client.
Yes. So you have to pay some amount.
Absolutely.
We have to pay some amount to they're telling with regard to that they are demanding now 70. What is how your client is labeled? What is your client?
She's a
76-year-old
woman, my lord, director of sole. Presently, there are no other directors, sole director of the company, my lord. She does not have any income of her own. She has to procure it from her son, who's in Dubai, who has to come, my lord. That's why I'm seeking some time, my lord.
Okay. Sense suffering for the plaintiff, sense suffering for the defendant. The defendant has filed an application being GA-Com 5 of 2024, challenging the report submitted by the special referee. Police. Counsel for the defendant submitted. The defendant is bedridden and he requires further time to take instruction whether they are going to settle the dispute as per the demand raised by the plaintiff.
It is in writing letter.
As per the demand raised by the plaintiff. We have the above. The case is adjourned. Let the matter appear. So I am fixing in the month of June, 11 June.
I'm extremely grateful.
In the meantime, let them take
Of course.
I'm grateful.
I'm extremely grateful.
Number 8.
My lord, my application, my lord, I am the plaintiff in this suit, my lord. This application, my lord, is for judgment upon admission. My lord, before I begin, my lord, with the application, may I just place a few facts for my lord's consideration? My lord, the writ of summons, my lord, in this matter was served on the 22nd of September 2022, my lord. My lord, there is a report from the office of the sheriff indicating this fact, my lord. My lord, thereafter, my lord, the deputy registrar gave a report. My lord, that was on 9th of December 2022.
Yes.
My lord, indicating that no one has entered appearance.
Correct.
My lord, subsequently thereafter, on the 6th of December, this application was filed. And there's a pleading in this application saying that the defendants have not entered appearance based on that 2022 report, my lord. After this happened, my lord's pleasure on the 3rd of January of this year was to pass an order. We had attempted service of this application. It had come back. My lord's pleasure was that you attempt again. We attempted again, my lord. My lord, thereafter on the 9th, my lord, we received an intimation from the office of the learned registrar that the defendant have entered appearance through a certain advocate. My lord, that was there. The report is there. After which, my lord, before that report could come in, we had already attempted service on the 6th of January, pursuant to my lord's order of 3rd of January. It had come back. There was an attempt by speed post. It had come back. Addressee cannot be located. Thereafter, a hand service was attempted. The door of the addressee, as mentioned in the plaint, where the writ of summons was served, that was found to be locked. My lord, we have evidence to that effect. My lord, thereafter, on the 24th of January of this year, my lord, the advocate who was indicated to have entered appearance on behalf of the defendant, he was served with a copy of this application. On the 30th of January, my lord, this year, he said he's retired from the brief. My lord, this is where it stands today. Now, my lord, coming to this application, my lord, the suit for goods sold and delivered, price not paid, no written statement on record, my lord, only the fact that they have entered appearance from the registrar's report. We filed this application for judgment upon admission. My lord, if I may now take my lord through the application.
Instead of the judgment upon admission, why you're not entering into the evidence, reading the evidence?
My lord, there is, I'll indicate, my lord. My lord, the evidence, the trial aspect, my lord, in the respect, my lord, it would be taking time. My lord, there is a categorical admission, signed admission from the defendant to the effect that they owe money. My lord, we are relying on that and we are trying. My lord would kindly take note. My lord, between the 4th of July 2019, I'll just give a background of the facts. I'll take my lord through the documents thereafter. My lord, between July 2019, specifically 4th of July 2019 to November 19, 2019, goods were sold. My lord, the total value was 16 lakhs odd, out of which money was paid in part. That was adjusted against this amount. My lord, thereafter, money being due, the parties entered into, they had a meeting. My lord, this was on the 9th of August 2021. They had a meeting where a minutes was signed. The plaintiff...
Admitting the claim.
My lord, the plaintiff, the defendant, and 2 other witnesses who also endorsed on that minutes. Where, my lord, the terms which were essentially agreed was that the due, which was in the range of 11 lakhs odd, will be paid by November of that year. If it is paid by October of that year, no interest, but thereafter 12% interest. My lord, then there was also an agreement that further goods would be supplied by the plaintiff to the defendant and they would get a certain discount, etc. That was agreed. My lord, that is not perhaps relevant because that is not a case in issue here. My lord, that happened. Thereafter, as a matter of fact, the parties acted upon the agreement by the defendant placing an order for which was mentioned in the minutes. The plaintiff supplied those goods. Money was received. Now, my lord, the money which was received was slightly in excess of what was the value of those goods. Approximately, my lord, very minuscule change. That was adjusted against the earlier dues, which was supposed to be paid by them. That happened, my lord. Thereafter, nothing. A notice was sent by the advocate for the plaintiff claiming the money, not acted upon. My lord, this suit gets filed. My lord, if I may just take my lord through the documents now. My lord, starting from page 44 of this application. My lord, these are all certain goods. My lord, there's no dispute so far as that is concerned. my lord, would find from page number 44 to 66. These are the invoices, my lord, which were raised.
Where is the purchase order?
No, there was no purchase order, my lord. There was no purchase order. My lord, these were given. My lord would take a note on, my lord, just as an example. My lord, these are all clothes which were supplied.
Eh?
My lord, clothes. The invoices, my lord, clothes were supplied. My lord, both are proprietorship concerns.
Okay.
Clothes were supplied. My lord, these are the invoices. Thereafter, my lord would see that the bank account statement starts from page 67, my lord. This is the plaintiff's bank accounts.
Yes.
My lord, this is only to show the money that we claim has been received. My lord, I'll indicate the amount also for my lord's convenience. My lord, 5,29,000.
So this 44 to 66. What was the total amount?
My lord, 16,35,934. My lord, would kindly take page 4 once. Paragraph 10. The supplies made between July 2019 and November 2019, my lord, aggregated to 16,35,000.
Page?
My lord, page 4. My lord, it's page 3 actually. My lord would kindly take paragraph 8.
Between July to census, goods census, 16 lakh. Okay.
My lord. My lord, then paragraph 10 at page 4, my lord.
Yes.
My lord, paragraph.
Paid 5 lakhs.
My lord. That was paid, my lord.
Out of 16 lakhs.
My lord. My lord would kindly have a look at paragraph 12 also, the minutes that I mentioned, my lord. The pleadings to that effect. Paragraph 12.
Yes.
The dues which were remaining were 11 lakhs odd, my lord, which is at paragraph 11.
Correct.
Then, my lord, at paragraph 12, my lord would kindly see the minutes, the pleadings to that effect.
Yes.
The terms are also, my lord, mentioned there. My lord would see towards the end, it mentions October 30, 2020, no interest. But it will be 21. It's a typographical error at the end. The third last line.
What is agreed for the payment?
My lord, and it was agreed that by November 30, they would definitely pay.
In the meeting, the petition also agreed the waive of interest of so subject it should be paid in its. It is 21, no?
My lord, these are typographical errors, my lord.
21.
I apologize.
The parties agree the payment made post interest at the rate of would apply. Okay. Then
My lord, this happened. My lord would see that the minutes, I'll take my lord to the minutes, but I'll just indicate, my lord, just to show that the 5 lakhs odd were received. My lord, we've given the bank statement as well, the plaintiff's bank account maintained with Punjab National Bank. That, my lord, would kindly see from page number. That's from page 67, my lord.
67.
My lord, those are the bank account statements of the plaintiff. Just to show that 5 lakhs was received.
67 to?
My lord, it starts from 67. My lord, 116 is the last page.
Yes.
My lord would kindly now come to page 117. My lord, a legible copy of what is there at 117. My lord would find a typed copy rather. My lord would find at 172.
172.
My lord. My lord, this is the minutes which I am referring to.
One.
My lord, there's one at 117. And my lord, there is separately annexed at page 171 and 172. 172 is the typed copy, my lord.
172. The other volume?
My lord, this is just one volume, my lord. My lord, till 170 is the plaint. 171 and 172 are just, the document is repeated.
172, yes.
My lord would kindly see 171. That's the document and the type copy is there. My lord, I'll
indicate for my lord, there is again a typographical error, which my lord would find at page 172. The first line, old dues of 11,06,323 shall be cleared within 30, it will be 30/11, my lord. Initially, it was written as that. It's been struck through, and but you will, my lord would find it at the earlier page 171. It says 30/11/2020. My lord, that is there. So, my lord, if I may just take my lord through what the agreement between the parties was in course of the minutes, in course of the meeting. Old dues of 11,06,323 shall be cleared within 30/11/2020. No interest shall be charged on payments remitted up to 30/10/2020.
Yes.
Interest at 12% per annum shall be charged for delayed period only after 75 days of interest credit for amount remitted in November 2020. New billings shall be at discount of 26% and payment for the same to be made in 15 days.
So
My lord.
now you come to the paragraph 12 that the 30th October 2020 is corrected. You stated that it should be 21.
My lord, the difference is, my lord, they had time to pay till November, but if they paid till October.
Finally, page 72, 172, no interest shall be charged on payment permitted up to 30 October 2020.
My lord.
Now come to the paragraph 12.
My lord, paragraph 12.
12 of the application.
My lord.
Last third line, 3 line. The party, no, last 5 line. In the meeting, the petitioner also agreed to waive the interest on the so and so, subject it to be paid October 2020.
My lord,
That's correct.
My lord, this date is incorrect. The one on the first line, my lord.
Huh?
The first. August 9,
21.
2020.
What is the date of the meeting?
My lord, that date is wrong, my lord. It has been typed as 2021, my lord.
That is 20.
My lord, that is
August 2020.
My lord, 9th August 2020.
So this 20, October 20 is correct.
My lord, 2020 is correct.
Correct. Only the 9th August 20.
My lord, because otherwise it would.
That's what
my lord, I follow, my lord.
Yes.
My lord would see then paragraph 5, my lord, this is relating to the new transaction which took place after the minutes were signed. Billing would be done as per the order received from such and such. Delivery shall be done at such and such place, my lord. My lord, 5 and 6 essentially don't really pertain to the earlier transaction for which the suit has been filed. It's just what the parties intended to do going forward. And my lord, this was actually acted upon by both the parties, as I indicated, my lord would kindly see that as well. My lord would kindly take paragraph number 14 and 15, my lord. We've pleaded to that effect as well. My lord, post the, or everywhere it's come as 21.
Yes.
My lord, post the meeting, there was an order placed for 3,21,920. And my lord, they paid 3,30,000. Now, my lord, the difference in the amount, my lord, that got adjusted and the due became, from 11, it became 10,98,000. My lord, that happened. Now, my lord would kindly see, my lord, if I may just take my lord back to the minutes once.
So this 3 lakhs.
My lord.
3 lakhs you adjusted in the old payment.
My lord, not 3 lakhs, my lord.
330.
My lord, they made a fresh order. They placed for 3,21,000. That was supplied.
Plaintiff sold and delivered the respondent goods worth of so and so. Such supplies were received by the respondent without any damage.
My lord.
Post meeting.
My lord, post meeting, another set of supplies was given to them, the value of which was 3,21,000 odd.
Correct.
They paid 3,30,000.
Correct. So 9,000.
My lord, and that has been adjusted. So 11 lakhs odd became 10,98,000. Okay. So that is essentially the due, my lord. Now, my lord, they didn't pay within time. A notice was also sent, my lord. I'll just indicate for my lord's convenience. Notice at page number. My lord, that's at page 126, my lord.
Yes, legal notice.
My lord, legal notice was sent,
Yes,
and along with that, all the bills were also annexed.
yes.
My lord, also my lord would find at page 155 the minutes as well.
155.
My lord. Just indicate, my lord, the postal receipt also for my lord's convenience.
Yes. 155.
My lord, 16. My lord, 155. The minutes was sent.
Minutes.
My lord was sent with the legal notice. My lord would kindly see 160 and 61. This was delivered. The postal receipts at page 160 and at 161 is the confirmation of delivery. My lord, that is there. My lord, this is essentially my case, my lord. The minutes, if I may just take my lord to the minutes to to show my lord who has signed, my lord. My lord would kindly take 171 again. With my lord kindly 172. The first signatory is Ajay Kothari.
170.
My lord would kindly take 171 and 172 together.
Yes.
The first signature is of a certain individual, Mr. Ajay Kothari. Then Sonia Kothari. Sonia Kothari is the proprietor, the plaintiff here. My lord, then Roopnath Pal, who is the proprietor of Gulmohar, who is the defendant.
Yes.
And there's a fourth person, Mukesh Begani. My lord, these are the four individuals who've signed. My lord, plaintiff and defendant have both signed. My lord, this is a confirmation. My lord, this is an acknowledgement of the fact that there's a due not paid. My lord, I've also showed that they are on notice of the fact of the due, this minutes, and my lord, their liability to pay. They don't file a written statement. This admission stands on record, signed by them, my lord, based on which I seek, my lord, judgment upon admission. My lord, I would just in this regard, my lord, I would just, I do not wish to bother my lord with too many judgments. It's just one which I found by my lord on a very similar issue involving price of goods sold and delivered, not paid. My lord would kindly, my lord would recall the judgment passed by my lord in Usha Martin. My lord, if I may just, my lord would kindly see, it's more or less on similar facts. My lord, here also, price of goods sold and delivered. My lord's pleasure in this judgment was to also consider Tata Steel judgment where admission in minutes was also considered. My lord, that's at page 27. I have also bought the Tata Steel judgment of Imami Alloy, my lord, which is there at paragraph 11. The tests are, of course, my lord, very stringent because it's ultimately my lord's discretion as to whether an Order 12 Rule 6 application is to be allowed.
Yes.
Just wish to place that. We also got Uttam Singh Duggal, my lord, but it's covered in the Tata Steel judgment.
Yes.
And thereafter by my lord also. Both judgments are covered in my lord's judgment. My lord, these are my respectful submissions. My lord, may I also give this Uttam Singh just for completeness, my lord.
Uttam Singh Duggal.
My lord has covered these two judgments in my lord's judgment. Both the Tata Steel and Uttam Singh.
Yes. That's all.
These are my respectful submissions, my lord. My lord, may I also file the affidavit of service pursuant to my lord's last order?
Yes. So, insistence suffering for the plaintiff on behalf of the defendant. The plaintiff has filed the affidavit of service. Let the same be completed. In spite of service of notice, none appears on behalf of the defendant.
My lord, may I just interrupt for one? My lord would kindly take the affidavit. I must indicate this to my lord. My lord would kindly take the affidavit of service, page 2, my lord. That's at paragraph 2. Here again, there's an incorrect statement made, my lord. I'll indicate. It has been mentioned, my lord, the item returned insufficient address. But my lord would kindly turn over to page 6.
Where mentioned?
My lord, paragraph 2 of the affidavit of service. My lord would find from in between the paragraph, item returned insufficient address.
Item, yes.
My lord would kindly see by page 6. This is incorrect. The statement made is incorrect. My lord, it is actually addressee cannot be located, which my lord would find from the postal tracking report at page 6.
Could not be located. Yes.
And my lord, thereafter, the hand service is also there. My lord, the photographs of the door being locked and all are also there. My lord, it's annexure B, which is page 10 onwards. And my lord, service on the advocate who entered appearance, my lord, that's at page 12.
You are the advocate on record.
My lord, the advocate on record was served by my advocate on record. My lord, on this, my lord, perhaps would my lord kindly consider this is his reply.
No.
And my lord, this is the report from the learned deputy registrar.
Since appearing for the plaintiff, none appears on behalf of the defendant. Police. In terms of the order passed by this court dated January 2025, and again sent a notice to the defendant and has filed the affidavit of service. As per the affidavit of service, it reveals that the notice was sent to the defendant by speed post, but the same was returned with the endorsement. Addressee cannot be located. In the meantime, the plaintiff has also obtained report from the Deputy Registrar of Legal dated 9th of January 2025, wherein the plaintiff found that the defendant has entered appearance through Mr. Soumya Bandyopadhyay, an advocate, on 14th of December 2022. When the plaintiff came to know about the same, the plaintiff had served the notice to the learned advocate on record of the defendant on 28th of January 2025. On receipt of the said notice, the learned advocate for the defendant had sent an email to the advocate on record to the plaintiff, intimating that he has retired from all the briefs of the matter of the defendant in connection with in connection with the present case. Let the affidavit of service be kept in the record. The plaintiff has filed the present application being GA Comp 2 of 2024, praying for judgment upon admission. Judgment upon admission for an amount of rupees 10,98,243. 243 along with interest at the rate of 12% per annum per annum. And counsel for the plaintiff submitted in between 4th July 2019 to 19th November 2019, as per the request of the defendant, the plaintiff has supplied goods sold and delivered to the defendant, being the ready-made garments, total amounting to rupees 16,35,934. The supply made by the plaintiff was duly received and accepted by the defendant without any demur or protest. Full stop. The till 5th March 2020, the defendant had made part payment amounting to rupees 5,29,611 out of the total amount of rupees 16,35,934. Full stop. Subsequently, the defendant has not paid any amount in spite of several requests made by the plaintiff to the defendant. Number next. On 9th of August 2020, a meeting was held between the plaintiff and the defendant, which was also attended by two individuals, and the said meeting was recorded in writing, wherein it was agreed between the plaintiff and the defendant that the defendant will pay an amount of rupees 11 lakh 6,323 within 30th November 2020. It was further agreed that if the defendant failed to pay the total amount by 30th October 2020, if the 11th October, 30th November 2020, full stop. It was further agreed that no interest shall be charged on payment remitted up to 30 October 2010. 30 October 2020. Full stop. It is further agreed between the parties that if the defendant failed to pay the amount by 30th October 2020, an interest at the rate of 12% per annum shall be charged for delayed payment. It was also agreed full stop. The post meeting of August 9th, 2020, the plaintiff had again sold and delivered the goods to the tune of rupees 3,21,920, and the said goods were duly received by the defendant without any demur and protest. On receipt of the said materials, the defendant had paid an amount of rupees 3,30,000, and as such, the plaintiff had adjusted the balance amount out of rupees 3,30,000 from the old dues, which was due and payable by the defendant to the plaintiff. Accordingly, the defendant is liable to pay the further amount of rupees 10,98,243. In spite of the agreement entered between the parties, the defendant failed to pay the said amount. Accordingly, the plaintiff had issued a legal notice to the defendant on 25th of August 2021, calling upon the defendant for payment of rupees 10 lakh payment of this. Where is the principal amount? You have not mentioned the principal amount. Payment of rupees 10,98,243 along with interest at the rate of 12% per annum, total amounting to rupees 12,92,465.69. The said notice was duly received by the defendant, but in spite of receipt of the said notice, the defendant has not paid the amount according the plaintiff has filed the instant suit for recovery of the said amount. After filing of the suit, a writ of summons was served, and writ of summons was served.
My lord, I'll just, my lord, I
The same
handed
thing.
over, my lord, it was, no, my lord, it was delivered, it was taken.
Writ of summons was served, but in spite of receipt of the writ of summons, the defendant has not entered appearance.
Post the notice, my lord, one fact I must indicate, my lord, would kindly take page 60, page 6, paragraph 16. 2000 was paid post the issuance of that notice, and my lord, that my lord would find the entry at page 162. My lord, it's
okay. I will come.
39. My lord, that entry is there.
But in spite of the writ of summons, none appears on defendant has failed to enter appearance, and according the suit was placed in the list of undefended. And according the plaintiff has filed the present application, the notice of the present application was also served, also sent to the defendant, but the same could not be served as the addressee could not be located. But it was found that the defendant has entered appearance, and the learned counsel for the plaintiff has served the copy of the notice to the learned advocate appearing for the defendant. But the learned advocate for the defendant has informed the plaintiff that he has retired from the case. Accordingly, the matter is taken up for hearing. Full stop. It is fine from the record. The plaintiff has claimed an amount of 12,92,465.69 along with interest at the rate of 24% per annum from the 24% per annum from the defendant on the ground that as per the request of the plaintiff, the defendant, as per the request of the defendant, the plaintiff has supplied the materials to the total tune of rupees, to the total amount of rupees 16 lakh, 11 lakh, just a minute. 16 lakh 35,934, out of which defendant has paid only rupees 5 lakh 29,611, and subsequent a meeting was held on 9th of August 2020, 9th of August 2020, wherein it was agreed wherein both the parties in presence of two independent witnesses has agreed as follows. Set out page 171. Okay. Set out page 171. Full stop. After this said agreement, the plaintiff had again supplied the materials for a total tune of rupees 3,21,920, out of which the plaintiff has, out of which the defendant has paid rupees 3,30,000, in which the plaintiff had adjusted the remaining amount out of the total balance amount of rupees 11,06,323. In the meantime, the plaintiff had also, defendant has also paid an amount of rupees 2,00,000 to the plaintiff on 25th.
My lord, it was on 13th of September 2021.
On 13th of September 2021. Thereafter, the plaintiff, thereafter, defendant has not paid any further amount. Full stop. On 25th of August 2021, the plaintiff had sent a legal notice along with the legal notice calling upon the defendant to pay the amount of rupees 12,92,465, which was duly received by the defendant on 28th of August 2021. But in spite of receipt of the said notice, the defendant has not paid any further. Considering the submission made by the counsel for the plaintiff, peruse the materials on record. This court find that by a meeting dated 9th of August 2020, the defendant had admitted the claim of rupees 111,06,323 as on 20th August 2020. Full stop. In this meeting, it was also also agreed that he will clear the dues by 30th November 2020, and it was also agreed that by 30th October 2020, if the defendant pay this total amount, no interest will be charged, and if the defendant failed to pay the amount, interest at the rate of 12% shall be charged. At the rate of 12% shall be charged. Full stop. In spite of this agreement, full stop. After this agreement, the plaintiff had supplied the materials for a total tune of rupees
3,21,920.
3,21,920, but the plaintiff has paid on 3,30,000. Thus, the balance amount was adjusted by the plaintiff to the earlier balance amount, and the defendant has not paid the balance amount of 10,98,243 as agreed by the defendant. Full stop. Considering full stop, the plaintiff has relied upon the judgment in the case of Himani Alloys Limited versus Tata Steel Limited, reported in 2011, volume 15, SCC 273, Uttam Singh Duggal and Company Limited versus United Bank of India and others, reported in 2000, volume 7, SCC 120, and the unreported judgment passed by this court in the case of Usha Martin Limited versus Hema Spring Private Limited and others, in the case in CS Com number 387 of 2020-24, dated 28th of June 2024, and submitted that this court has considered and submitted that the defendant in the present case has admitted the claim of the plaintiff by entering into the minutes of the meeting in presence of the plaintiff as well as in two independent witnesses. In spite of admission of the claim, the defendant failed to pay the said amount. Full stop. Counsel for the plaintiff submitted the judgment relied by the plaintiff is squarely applicable in the present case and is entitled to get the judgment upon admission. Considering the materials on record and the judgment relied by the plaintiff, this court find that the plaintiff in the minutes of the meeting dated 9th of August 2020 has admitted the claim of rupees 11,06,323, wherein he has admitted that he will clear the said amount by 30th November 2020, but the defendant has not paid the said amount. As per the said agreement, the plaintiff has supplied further materials for a total sum of rupees 3,21,920, but the defendant has paid rupees 3,30,000, and the plaintiff has adjusted the 9 lakh odd amount in the balance amount of rupees in the earlier due amount of rupees 11,06,323, and the remaining balance is required to be paid by the defendant is rupees 10,98,243, which the defendant has not paid. Considering full stop. Taking into consideration, this court finds that the defendant has admitted the claim of the plaintiff but has not paid the amount. Thus, and the defendant has also agreed that if he failed to pay the said amount, the defendant will pay interest at the rate of 12% per annum. Considering the above, this court finds that the plaintiff is entitled to get the judgment on admission for a total sum of rupees 12 lakh 92. No, where is the amount? Is entitled to get an amount of rupees 10 lakh 98,243 along with interest at the rate of 12% per annum from 22nd October. Why 22nd October? Last payment was made.
My lord, the last payment was made, my lord, on 13 September 2021, which is at page 162, my lord. That is the 2000 which was paid, my lord, after the issuance of the legal notice.
13?
My lord, page 162, my lord would find it September 13, 2021, 2000 rupees paid by the defendant after the issuance of the legal notice.
With effect from? No. With effect from 14th September 2021. 2021 till the realization of the decretal amount. The defendant is directed to pay the amount of rupees 10 lakh 98,243 along with interest at the rate of 12% per annum from we did till the realization so realization. GA Com 2 of 2024 is disposed of. Accordingly, CS Com 315 of 2024 is disposed of. Decree be drawn accordingly.
My lord, for my satisfaction, may I just indicate, my lord, because there was a typographical error which my lord had also seen. My lord would kindly see page 127 once. Just for my satisfaction, my lord, I do not.
127.
My lord, of the 127, my lord would find the correct date mentioned there, my lord, starting from paragraph 4. My lord,
2020.
my lord, I just wanted to point that out. And my lord, this is also one thing, my lord, for my lord's kind consideration. This is a report showing no written statement was filed as on January 2025.
Okay, that I
My lord, my lord. Grateful, my lord, grateful.
My lord. And in this matter, my lord, I have filed the application being GA5 of the
Yes.
and this, my lord, has could not be served because the erstwhile advocate has retired, my lord, and he has refused to take the service. My lord, I am paying for a service upon the bank and come back after 2 weeks.
Since suffering for the plaintiff, none appears on behalf of the defendant. Counsel for the plaintiff prays for 2 weeks time to serve the notice of the present application upon the bank. Accordingly, case is adjourned. Let the matter appear on 8th May. 8th May.
In this matter, appear on behalf of the defendant. Item number 10, my lord, in this matter, I am appearing for the plaintiff. I may be permitted to appear virtually, my lord.
Yes.
My lord, GA Com 10, my lord, is my application. My lord, by an order dated 3rd January 2025, your lordship had allowed certain amendments. My lord, during while carrying out the amendment, there were certain errors, which was my lord, lordship passed an order on 17th February, which is at page 9 of my application. My lord, by that order, my lord, your lordship had directed me to take steps for carrying out the rectification. My lord, this is that application by which, my lord, the re-verification, my lord, the name of the plaintiff has been mentioned as the director of the erstwhile plaintiff, which has been now be merged with the present plaintiff. So, my lord, this is my application, my lord, to carry out the amendment because the department is not allowing me to carry out the amendment because of the error apparent from the record, my lord.
Yes, who is appearing for the other side? You.
No, I appear on behalf of the defendant. I do not have any objection. The plaintiff has been mentioned as Vikas Chandra Jana. In fact, by when your lordship had passed an order dated 3rd of January, I had given my consent. Let me carry out the verification and the service may be, the amended plain may be served on me through the department. I shall do that.
So suffering for the plaintiff. So suffering for the defendant. Plaintiff has filed an application being GA Com 10 of 2025, praying for amendment as shown in Annexure C in the present application. Consider the submission made by the counsel for the parties. This court finds that the amendment as sought for by the plaintiff is formal in nature and will not change the nature and character of the suit. Accordingly, prayer
The prayer for amendment was already allowed by your lordship by an order of 3rd January. This application, I'm only praying that I can take appropriate steps to reaffirm and re-verify the plaint by changing the name of the deponent.
that is annexive. That is a verification.
My lord, that is also an error.
Correct. So prayer A2I of the master summons. Police, after carrying out the amendment, the plaintiff is directed to serve the amended copy of the plaint to the defendant as entered appearance in the suit.
My lord.
The amended plaint may be served
within a week
through the department on the defendant. Yes, I will.
Within a week from within a break from the date of of the plaint to the plaintiff to the defendant within a week thereafter.
In the usual manner, my lord.
Yes.
Through the department.
Grateful, my lord. Grateful.
My lord, I am for the plaintiff in this matter. This was an application for extension of time to file the written statement, and that was allowed by your lordship on 3rd of December. And they have filed it also, filed the written statement.
Lordship, I am appearing for the defendant state, Lordship. Lordship will kindly permit me to appear virtually.
Yes.
Yes, Lordship, this written statement has been filed. Cost has been put in, Lordship. The time to complete discovery inspection and come back with suggested issues, directions may be given, Lordship.
I appear for the defendant number 1. Our written statement has also been filed.
That is 81.
J2 dispose of ho gaya.
Yes, yes. This
the general applications have been disposed of.
Item number 81, 82. Similar orders be passed.
81, 82.
Yes, my lord.
Lordship, 3 suits have been filed.
All
first,
the suits that this court has granted
yes,
written as
yes.
you filed.
Yes.
Mr. Gupta, you are appearing on the other suits also?
Yes.
No, my lord, only in CSCOM 613 of 2020.
Item number 81.
I am assisting Mr. Gupta.
81 also.
Yes, just in it.
Yes, sir. No, this one?
This one we are-
11?
This
You are
one.
11, you are
This
not
Gupta
appearing. 11 who is appearing for the defendant?
Lordship, defendant state, Lordship, I am appearing. Lordship will see defendant number 2 is the state.
Who is a government of West Bengal? Then why you are not appearing for the joint secretary, small and medium? That is
all
Together, Lordship, defendant number, all of them.
All.
Defendant number 1, yes. 2, 3, and 4.
One is not appearing. What about the one? Notice
One-
out.
One is appearing. They have filed their.
Achha, you have filed.
They have filed
And
their.
what about the state? You have filed the written statement.
Yes, Lordship, we have.
So appearing for the plaintiff. So appearing for the defendants number 2 to 4. And 1, who is appearing for 1? Nobody is appearing for the 1.
No, we are for 2, 3, 4.
None appears on behalf of the defendant number 1. It is fine from the record. Defendant number 1 has filed written statement.
Yes, my lord. Yes, my lord. Yes, filed.
Yes.
And he's
It is
paid
fine
the
from the
cost.
record. Defendants have filed their written statement. Full stop. And the parties are directed to complete the discovery and inspection of the document within 3 weeks.
4 weeks.
State
After vacation.
within 4 weeks.
After vacation would be better because this
Similar orders may be passed in 81 and 82.
Yeah, but
Your lordship makes it after vacation.
I will fix in the vacation, but within 4 weeks. Full stop. Affidavit of admission and denial of the document be filed within 2 weeks thereafter. Within 2 weeks after the summer vacation. Full stop. In the meantime, the parties are also directed to complete the to exchange the suggested issues. Release the matter on 24th of June 2025 for framing of issues. 81.
81.
You're muted.
Lordship, Lordship, I believe the written statement of the defendant number 1 has not been served upon the rest of the defendants.
No, nobody is here. No defend, but the written statement is on record.
Lordship, a direction may be given. Lordship, I do not know what is the stand taken by the defendant.
Not having
for the 2, 3, 4. She is my counsel.
That's why you're not having the copy of the written
No,
record.
Lordship.
Counsel for the defendant number 2, 3, and 4 submits that not the defendant number 1 has not served the copy of the written statement to the defendant number 2, 3, and 4. Accordingly, the defendant number 1 is directed to serve the copy of the written statement to the defendant numbers 2, 3, and 4 within a week from date.
I'm grateful.
Yes, 81.
82.
81 and 82.
Yes.
Yes, Lord.
That also.
The only possible correction would be that our written statement is served on all the
Yeah, all. Even the other one, we have served.
In item number 81, possibly the only change would be from the order that the written statement that we have filed have been served on all the
Maybe that may be.
That is the only.
81 and 82. Same. It's the same parties.
Same parties. Not the same.
Same parties.
The defendant number 1 is different.
The defendant number.
Defendant number 1 is different.
One is different.
Yes.
But written statement is filed.
Yes.
81, 82. So and so appearing for the plaintiff, so and so appearing for the defendant 1, and so and so appearing for the defendant 2, 3, and 4. It is fine from the record. The defendants have filed their written statements accordingly. बस वही कर देना. ठीक है. खाली last वाला मत करना. What is the director to complete it? Same state में रख देना.
Extremely obliged.
Grateful.
My lord,
Your Lordship, I'm
my
appearing for
application,
the...
my lord, for extension of time to file, my lord, my written statement to their counterclaim, my lord, may I place it? I believe, my lord, defense had been made, my lord, on the last occasion that the time to file, my lord, my written statement to their counterclaim has already expired. My lord, I'll demonstrate that's not the case. May I place, my lord, my application? That's GA2.
You are appearing plaintiff.
So for the
Defendant.
defendant, Your Lordship.
Yes.
That's
GA2.
GA2, my lord.
Yes.
We haven't been served with this application.
It's not been served. I'm serving you right now. But I've handed over my application, my lord. I'll argue, my lord, on the basis of my recollection to the best of my
Ready?
recollection.
Yes, Your Lordship.
My lord, there's nothing much there, my lord. I'll summarize, my lord. They had filed, my lord, a counterclaim to my suit, my lord. That counterclaim, my lord, was accepted, my lord, by my lord's order of October 4th, my lord, 2024. My lord, may kindly take that order.
October 4.
October
You
4.
are having the copy?
Yes, my lord, I'm carrying only one copy. My lord, this is the day on which, my lord, the counterclaim was formally, my lord, filed and lodged with this honorable court. My lord may next kindly take my lord's order of January 6, 2025. No.
6 January, yes?
Yes, ma'am. My lord had mentioned, my lord, I must fairly place this order, my lord. This is what they will rely on to say my time has expired. My lord may kindly take page 2 of my lord's order of January 6, 2025. My lord had given me a time of 120 days on receipt of the written statement along with counterclaim.
Shall be not beyond the 120 days.
from date of receipt of the counterclaim.
Correct.
That, my lord, with the greatest of respect, my lord, is no longer proper law, my lord. I am fortified, my lord, by two decisions, my lord. One is of the Delhi High Court, one is of the division bench of this honorable court, my lord, which says that 120 days period for filing a written statement to a counterclaim, my lord, will only arise once the written statement has been, once all the defects in the written statement has been cured, my lord, the department has accepted. To that extent, it is treated as a plaint, my lord, and consequently, my lord, the proceeding insofar as service of summons of a plaint, my lord, will follow. If I am taking, my lord, from that date, if I am only considered from October 4th, my lord, I am well within my time period, my lord. I had filed the written statement on that 120th day itself, my lord. I've explained that with sufficient particulars, my lord, in my application.
When the written statement,
Yes,
the corrected written statement was served upon you.
My lord, the corrected written statement was never served on me, my lord. I was served before it was filed before this honorable court.
That's correct. That is the order
Yes,
reflex.
yes.
So there was a defect.
Your Lordship, we haven't served the corrected written statement yet because we need to file 2 documents to correct the written statement.
So you're not served the corrected written statement.
No, Your Lordship.
I can place those judgments, my lord, if my lord, for my lord's satisfaction, I can place those decisions. My lord, I'm fortified, my lord. I'll start with the Delhi High Court decision, my lord.
Why not this division?
Very well, very well. It was actually, my lord, from my lord's order that went up to the, perhaps my lord is aware. My lord, I'll directly come to, my lord, the relevant part. My lord, kindly comes to para 16, my lord. That's at internal page 6 of the decision. Yes. My lord, may I place it? The question thus arises is whether reply to a counter statement is required to be filed within 120 days from the service of the written statement with counterclaim upon the plaintiff. The written statement with counterclaim has been filed in a commercial suit. The provisions of the Commercial Courts Act 2015 is applicable with regard to the pleadings and procedures to be followed as mentioned in the schedule of the Commercial Courts Act. Under the schedule, various provisions of the Code of Civil Procedure was amended and are made applicable to commercial suits. One of such provisions is in respect of written statement. By reason of amendment of Order 8, Rule 1 of the Code of Civil Procedure, the defendant would be required to file a written statement not later than 120 days from the date of service of summons, and on expiry of the 120th day from the date of service of summons, the defendant shall forfeit the right to file written statement, and the court shall not allow the written statement to be taken on record. Although the other provisions of the Code of Civil Procedure have not been amended, but Order 8, Rule 6G is clear that rules relating to written statement by a defendant shall apply to a written statement filed in answer to a counterclaim. This was introduced by the Amendment Act of 1976 with effect from so-and-so. Order 8, Rule 9 of the Code of Civil Procedure contemplates that the court may at any time require written statement or additional written statement from any of the parties and fix a time not more than 30 days for presenting the same. The provision does not in any event enlarge the time fixed under Order 8, Rule 1 as amended by the Commercial Courts Act 2015. The counterclaim in a written statement is treated as a plaint, and the plaintiff may file an additional written statement in answer to the said counterclaim in view of the fact that the suit was filed in the original side of the High Court. The procedures insofar as filing, scrutiny, and other related matters are concerned, in absence of any practice directions, shall be governed by the original side rules unless these rules are not in conflict with the procedure prescribed under the Commercial Courts Act. Then, my lord, Rule 12A, my lord, of the original side rules, my lord, is placed in para 18, my lord. I am not bothering, my lord, with it. My lord, kindly takes para 19, my lord. This is a factual distinction, my lord. I am covered by this, my lord. This does not affect me in any manner. I'll demonstrate. But admittedly, the written statement was served on 18 July 2023, and the defendant was permitted to file the written statement with counterclaim by an order dated 13 July 2023. In terms of the order dated 13 July 2023, the department could accept the written statement provided it was filed on that day on the basis of the endorsement on the fate, and the same is in proper form and order. On fiat, and the same is in proper form and order. The original written statement is produced by the department, wherefrom it appears the written statement with counterclaim was presented on 13 July 2023 and was accepted by the department, meaning thereby it was in proper form and order. The department could not have accepted the said written statement if it were not found to be in proper form and order. Although we are of the view that a written statement with a counterclaim can be served only after scrutiny upon the plaintiff, and thereafter the time to file reply to the counterclaim would arise. However, the said issue is not germane, my lord, because in the facts of this case, my lord, it was admittedly on 18 July 2023, the written statement was served after the department accepted the written statement. This is not done so in our case.
Correct.
This is the only differential criteria on the basis of which the court did not interfere with my lord's decision.
That's why, when, have you served?
Your Lordship,
That's
today
not-
only we have received the application
What?
by my learned friend stating that
That's
extension
correct.
of
That's
time.
correct. That's correct. See, you have filed the written statement along with the contract claim. Correct.
Yes, Your
This court
Lordship.
has accepted subject to scrutiny.
Yes, Your Lordship.
When the scrutiny was completed.
Your Lordship, the scrutiny was
Possibly there were some defects, my lord, subject to correction, my lord.
Defects means when the scrutiny was completed, the defects was cured.
Your Lordship, the defects have not been cured yet because
date.
Your Lordship, I have gotten the 2 documents that I need to file in court, and then only the defects will
What
be.
document?
Your Lordship, one is affidavit as per Order 9, Rule 6.3, and one is the list of documents.
How it can be?
Look, these are fatal errors, possibly. Possibly. My lord, I stand
The
corrected.
Commercial Court Act,
I bow down.
after filing of the written statement,
I
you have not taken leave for the document.
Your Lordship, there were some errors in these 2 documents, and that is why
Document you filed, or in the document there is an error, or you want to give the additional document?
No, Your Lordship, we have filed the document and there's an error in the document. So we want leave to take back the document and file the new document.
Huh? Decretal amount prior of the written statement is not in conformity with paragraph 20. Acha, affidavit under order 11 rule 6 filed with the written statement not in proper form.
Yes, Your Lordship.
You want to file the affidavit and list
Your
of
Lordship.
document annexed with the written statement not in conformity with the list of relied. Signature of the advocate of the defendant is absent. So this is when the 16 December.
Yes, Your Lordship. And
What you have done after 16 December?
Your Lordship, after 6 January of Your Lordship's order, we had the matter is listed today. So we had to take leave from Your Lordship to file these additional documents.
That application is not before this court regarding
Lordship,
additional
I
document.
have, it's not, Your
That
Lordship.
cannot be filed here. It
Your
should be a master summon if you want to rely upon this additional
Your Lordship,
document.
these are not additional documents. There are already a list of documents in the
Well, if I may be fair, my lord, these are possibly documents that form part of the defense.
But there are defects in these documents, so we have prepared the new one.
So how
defects.
this court can, unless and until you bring all the things on record by way of application. So then you have to bring the original document which you annexed with the counterclaim and the written statement and the document which you relied upon. Then the court has to compare whether it is, then the court only relying upon this document, how the court can allow you.
My lord, kindly take order 11.
That's
Your Lordship.
It says shall, my lord, and it says that the plaint shall also
Correct.
contain a declaration note from the plaintiff
Correct.
with all
So
the documents.
that's why the court has to compare
I bow
whether the same document or only
I bow
something
down.
is
I
then,
bow
then it is correct.
I bow down.
If it is additional document, then
Your Lordship, these are not additional
they have to
documents.
face the hard.
I bow down.
Your Lordship, these are not additional documents. There were error in the form of the document. That is why we are.
So it is the department procedure, madam. What the court will do?
We just want the leave of Your Lordship to file these in the department.
How this court can allow at this stage? You file the written statement on all these things. How this court can allow? Kindly go. You have gone through the report, defect report.
Yes, Your Lordship.
So defect report, you have to go to the master. If the master is having some problem, then they will submit the report to this court.
Okay.
Written karo.
Your Lordship, if Your Lordship may fix the matter in 2 weeks when we can cure the defects and then we can
I
give
am
our
keeping your
reply.
application pending.
Yes,
So
give our reply to their application.
What have reply?
My lord, these are matters of fact. I've only indicated, my lord, the day of the
This is a point of law. One thing. Second thing, till date, admittedly, you're not cured the defects of the written statement. If you're not cured the defect of the written statement and the counterclaim, how they will file the written statement?
Yes, Your Lordship.
That's the division bench has held. Because there is no procedure, that's why the division bench in one paragraph it was justified. Clarified. Sensation supreme for the plaintiff, sensation supreme for the defendant. The plaintiff has filed an application being GA-Com 2 of 2025, praying for acceptance of the additional written statement to the contract. It is fine from the record. The defendant has filed written statement along with the contract claim after serving the same to the learned counsel for the plaintiff. But at the time of scrutiny, the department has pointed out altogether 4 defects in the written statement along with the contract. And the same was duly notified by the department to the learned counsel for the defendant. So counsel for the defendant submitted. The defendant has not yet cured the defects as pointed out by the department and prays for 2 weeks time. This court find that unless the defects which the department has notified to the defendant is not cured, the application filed by the plaintiff being GA5 cannot be taken up for hearing. Accordingly, let the GA-Com 2 of 2025 be kept with the record. The plaintiff is directed to, the defendant is directed to rectify the defects within 2 weeks from date. This is the matter on 7th May 2020.
Grateful, Your Honor.
Grateful.
Lordship, I beg to appear under the plaintiff. Lordship, my petition for my two application, Lordship, is for Lordship substitution and another is for Lordship condonation of delay of 1 day only, Lordship.
What 1 day?
I appear for the
1 day
defendant.
1 day delay, Lordship.
Delay for what? Written statement?
No, Lordship.
No.
Substitution petition.
Substitution petition.
Yes, Lordship.
No,
Lordship.
the suit has abated. The
Yes,
suit has
please.
abated. The
Lordship.
suit has abated, Your Lordship.
Lordship, may I submit my application first? Lordship.
Yes.
May I allow Lordship that Lordship kindly seize the Lordship my application for substitution, Lordship.
Your application with IGA number?
GA8 of 2024, Lordship.
Yes.
Lordship, affirmed on 4th October 2024. Lordship,
Affirmed on 4th October 24.
Lordship, sole plaintiff died on 5th August.
Filed after 1 month.
No, Lordship.
October, yes. 4th October.
Yes, Lordship. Yes. I filed after 1 month, Lordship. Lordship, sole plaintiff died on 5th August 2024. So my limitation.
24.
Yes, Lordship. My limitation complete on 3rd November 2024. I affirmed this petition for substitution, Lordship, on 4th October 2024, and I placed it before the Lordship department, concerned department for filing. Lordship, may kindly seize the Lordship cause title. So there are some error, Lordship, actually defect. Lordship, actually I
Filed the same in the department.
Lordship.
When you filed the same in the
Lordship, on the 4th October itself, Lordship.
October.
I placed it before the concerned department for filing, Lordship. Lordship, may kindly seize the Lordship cause title of my substitution petition. Lordship, there was some error, Lordship, because we incorporated certain thing which is not supposed to be in the substitution application, but because that is not the cause title of the Lordship plain. So department what did, Lordship, that on 8th October, the puja vacation, after the 8th October, that's from the 9th October, puja vacation was started for the 1 month, Lordship. Now, Lordship, department called me on 8th October and in the almost in the Lordship afternoon that there is some defect in your application. So you please kindly rectify those things. But Lordship, by that time, Lordship, I was on, the short of time, Lordship, I could not rectify those, Lordship. And I rectified in the meantime, and Lordship, on the just reopening, that is on 4th October, I placed it before the department with all rectification. So that is the Lordship. 4th November, I placed it before the just on the opening of the puja vacation, reopening of the puja vacation, Lordship. And 3rd November, I just crossed my limitation, Lordship. And that is the 1 day, Lordship. This is a delay of Lordship. That is the reason for delay of 1 day, Lordship. It is the only thing.
Lordship, I'm appearing for the respondent. I
appear for the defendant. But 3 dates Your Lordship will take. 5th August, 3 dates Your Lordship will take.
Yes.
5th of August 2024 is the date of death.
Yes.
90 days gets over on 3rd or 4th of October.
Yes.
No, Malad, 90 days gets over on 3rd of November. I'm so sorry. 90
Yes.
days gets over on 3rd of November. This application is filed technically on 4th of November, which is a delay of 1 day.
Yes.
There is no application for setting aside abatement filed along with the application for substitution because the suit has abated on 3rd of November. The application for setting aside abatement, which is GA9, is filed on 5th of December. That is beyond the 30-day period within which the application for setting aside abatement had to be filed.
Yes.
So as of today, the suit is abated. The application for setting aside abatement, which is GA9, is barred by time, and there is no application for condonation of delay. Your Lordship will get to GA9. Therefore, I have used an opposition. To GA8, I have not.
But Mr. Bose,
yes,
he has affirmed the affidavit on 3rd of October, 4th of October, and it was filed in the department on 4th of October. It is there in the record, but there was a defect. So whether it can be said that it is not filed within 90 days.
The defect was not cured within 90 days.
That is the technical defect, but the application in the department on 4th of October.
What had happened is they had completely changed the cost ID. So in effect, it was not even an application.
Whatever it may be.
I'm not standing in the way. But as of today, Malad, the suit abated on 3rd of November. The application for setting aside abatement has also not been filed within time, and that also is beyond time.
No, if it is taken into consideration, the application for substitution was filed on 4th of October.
If your lordship holds that date of filing is 4th of October, then GA9 is a surplusage. But if the date of filing, even in the court record, the CIS is showing that the date of filing of the application is 4th of November.
That is the problem.
I will not. I had to point this out. I leave it to your lordship.
That is the problem facing in the department. That's why on the last, just before this counterclaim.
4 days took lordship.
That is the counterclaim also the division bench is held, because unless it is cured, because if suppose you file the plaint this court is accepting the plaint subject to scrutiny.
Yes.
Scrutiny you are taking 2 years or 1 day or whatever it may be. The notice cannot be served unless the scrutiny is completed.
No, Malad, I had to point this out. If your lordship treats it as 4th of October, then GA9 is surplusage.
I will declare. I will.
So when I was on 4th October, there was almost lordship 34 days was in my hand. If puja vacation was not there.
See, if the court is with you, need not to say anything.
Lordship.
Keep them.
Malad, may I put my affidavit in opposition to GA9 on record, Malad? There was an order for filing. It has been served, Malad.
Okay, I am taking.
It has been served.
Obliged.
Okay, thank you. So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. The plaintiff has filed an application being GA8 of 2024, praying for recording the death of
sole plaintiff, lordship.
Recording the death of the sole plaintiff and substitution of the legal heirs of the plaintiff.
Yes.
Where is the details? Where you given the details?
Lordship.
Where the details of the legal heirs?
Lordship. It's lordship, paragraph 7, lordship. No, lordship. I am.
And where is the plaint amended plaint?
Lordship, that if your lordship allow us to, then we feel lordship. That
you have to. Few persons are doing so. If you filed an application for substitution, it's closing. You have to disclose.
Accompanied lordship that.
And where is the legal heir? Where is the name of the legal heir?
Lordship on paragraph 7, lordship.
Paragraph 7, plaintiff Niyati Chanda recorded the astral plaintiff and substituted her legal heirs Nikhil Ranjan Chandra and Nitish Chandra, respect of the aforesaid. Who are they?
Lordship, they are the sworn legal
Where
heirs.
it is? You're not consulted with the senior?
This was actually
Where it is? Who is he? And if it has been added also, where is the address?
that was actually, Lordship, we incorporated in the application itself, Lordship, that was rectified. That
what is
application, Lordship, the cost title we have actually incorporated the same, Lordship.
Incorporated, that has been done. You have deleted.
Lordship, that is
Then
on the advice of the department, Lordship.
If today this court allow this,
Lordship.
So how you will amend the how this department will add this? Where is the address? Yes, what will do?
Lordship, may I come back on Monday, Lordship? Lordship,
File supplementary affidavit.
I'm grateful, Lordship.
Census when suffering for the plaintiff, census when suffering and defendant. Plaintiff has filed an application being G8 of 2024, GCOM 8 of 2024, praying for recording the death of the sole plaintiff and substituted the legal heirs of the plaintiff. The plaintiff has also filed an application being GACOM 9 of 2024, praying for setting aside the abatement order. Abatement of the suit. The defendant has filed affidavit in opposition in connection with GA 9 of 2024. Let the same be got with the record. Full stop. Counsel for the plaintiff prays for leave to file supplementary affidavit in connection with GACOM 8 of 2024. Consider the submission made by the counsel for the plaintiff. Leave is granted to the plaintiff to file supplementary affidavit in connection with GA 8 of 2024 within 2 weeks from date. After serving the copy to the learned counsel for the defendant, let the matter appear on 8th May, on 14th May 2025.
Grateful.
Grateful, my lord.
Excellent, Lordship.
This is my in-purpose application for appointment of advocate commissioner for recording evidence.
Lordship, I beg to appear on behalf of the defendant, Lordship. Mr. Kartik Kumar Bhattacharya is out of station, Lordship. Lordship,
Commission appointment or commissioner?
Lordship,
For what? Recording evidence.
Evidence.
Lordship, we would file affidavit in opposition as per instruction, Lordship. Lordship, Lordship, my instruction is that we would file affidavit in opposition, Lordship. Lordship, kindly make it not today, Lordship. He is out of station, Lordship. Kindly make it not today.
Yeah, Commissioner, one of your friend will get benefit of this, and the court burden will be less.
Lordship, my instruction.
That's the
My
Tomorrow?
Not today, Lordship. Kindly make it not today, Lordship.
No, Lordship. As per the prayer, census suffering for the plaintiff, census suffering for the defendant. As per the prayer made by the counsel for the defendant, you are for the defendant.
Defendant. Insurance company.
The case is adjourned. Let the matter appear tomorrow. Come tomorrow with the instruction.
Yes, yes, Lordship.
Lordship, item number 15. This is my application. I have a copy of the defendant number 4 and 5. He was. Oh, sorry, I apologize, Lordship. I was
item number
15. No, I'm there for 7.
Your Honor, I'm for the petitioner. I am led by my senior Aditya Garodia and he will be attending virtually.
Huh?
He will be attending virtually.
Unmute. Not audible. Might be there is some microphone trouble. Kindly switch off and switch on. Who is for the defendant? Nobody is appearing. Have you taken steps for amendment in the name of the
The
defendant?
cost title and the address of the
Taken
respondent.
steps?
Sorry.
Print का है?
अरे दिए तो दिए बोले तो दिए मुझे और ऐसे नोट कर रहा था
মাইলার in this matter মাইলার landed advocate আদিত্য গার্গী তাকে but he don't touch on that I'm later Mr.
স্যারের মাইক অন হচ্ছে না স্যার ইজ ট্রাইং স্যারের মাইক অন হচ্ছে না অনেক ফোন করে
মাইলার there is an amendment kindly come to page number 5 man there is an amendment মাইলার
So appearing for the plaintiff. The plaintiff has filed the present application being GA Com 2 of 2025, praying for amendment in the house title with regard to the name of the defendant company.
and also add this that will be Nilam Bazar what has happened it should be Nilam Bar Delhi and 8B it should be 28B man.
Name and address of the defendant company as appearing in Annexure A of the proposed amendment. Consider the submission made by the counsel for the plaintiff, peruse the proposed amendment. This court find that the amendment as sought for by the plaintiff is formal in nature and will not change the nature and character of the suit. Accordingly, prayer
A, B, C, D, Your Lordship.
A to D of the master summary.
Deeply obliged. My apologies, my Lordship, for not being heard. Deeply obliged. Deeply.
But I beg to appear for the respondent defendant in this.
I appear for the plaintiff, Mullah. There are two applications on board, Mullah. GA1 is the application for judgment on admission and also security. Mullah had taken up a contempt matter relating to this matter. Mullah, security order has already been passed. Mullah, the contempt is proceeding. I'm not on that. The judgment on admission prayer is also there in my application. There's been directions for them to file an affidavit to that application since August 2024. No affidavit has come thus far.
As a last opportunity, my lord, I was praying for time because, my lord, what has transpired here also, Lord, there has been a change in the advocate on record. We had some difficulty. The new advocate on record had some difficulty in procuring the paper. Your lordship.
You are appearing.
I was appearing, my lord.
Yes.
I was appearing, but there was some difficulty, my lord, in between.
For what?
In procuring the papers, my lord.
Procuring the paper or paper in security?
Security, my lord, we have furnished it yesterday.
District cooperative.
But that was also a difficulty, my lord. Here also, as a matter of last chance, my lord, I was just praying. No further time will be sought after this.
And my lord, GA2.
My lord, there is also one more application, which is GA2. That is my application for extension of time to file written statement, my lord. But the commercial suit within
20 days over.
Within 128 on the 128 days, my lord, it has
When
been
the writ of summons was served?
served on 24th of July 2024. 24th of July 2024.
24th of July 2024.
Correct.
When you file the written statement?
21st of November 2024. That's the 128th.
This, my lord, I am not aware as to whether it was filed in the department
filed
or
in the
not.
department.
But here, my lord, we also have some difficulty, which is why I did not want to
Not
press
filed
the
in the
application.
department, nothing can be done.
My instruction is, my lord, this is my personal knowledge. I do not want to, my lord, make any submissions to that effect. It has been filed.
Okay,
But
I am calling the report.
let the report be called upon, my lord.
Supreme for the plaintiff, Supreme for the defendant. Counsel for the defendant prays for extension of time to file affidavit in opposition in connection with GA1.
GA1.
Affidavit in opposition.
GA1.
GA1 of 2024.
2 weeks.
That affidavit in opposition is filed within 2 weeks.
2 weeks.
Reply, if any, there to be filed within 2
Within a
weeks
week,
thereafter. Within 2 weeks thereafter. This is the matter on 10th June 2025. Full stop. The defendant has also filed an application being GA Com 2 of 2024, praying for extension of time for filing written statement. Counsel for the defendant submit that the defendant has filed the written statement in the department on 21st of November 2024, that is 1/20th day after receipt of the writ of summons. In view of the above, the department is directed to submit the report whether the defendant has filed any written statement on 21st November 2024 or any other date by the next date fix. This is the matter on the same day.
Only one frame, GA1 has fixed in June. Could it be sometime in May, It's a suit of 2024, admitted only in the list. I'm not seeking for any time. If it commences to 2 weeks, we'll
The matter जो जून बोला ना वो सच्चा 20 जून कर दो 20 मई कर दो
oblige.
दोनों को 20 मई कर दो.
Number 17. Item number 17. This is my application. I appear on behalf of the defendant number.
I am for the plaintiff, Milord.
4 and
Milord,
5.
the,
I'll just place my application. This is my demurrer application.
Application is not here. You are not filed. There is a report.
Your Lordship, we have filed. In fact, on the last occasion, it was proffered to your Lordship. This is my demurrer application under Order 7, Rule 11. They had taken time to file their affidavit in office.
we have been served with the application. We have been served. Well,
I believe it's
we have also drafted it, but it is yet to be settled, Milord. We are going to file.
Your Lordship, the office copy is there. Learned advocate on record.
I'm praying for a week's time to file the opposition.
They were already granted time. I can't.
On the only one.
What application you filed?
The Order 7, Rule 11. I happen to be the directors of the company. I have been impleaded in the suit. There is no cause of action that
You are for the defendant.
I'm for the defendant numbers 4 and 5.
4 and 5. What about the other defendant? So appearing for the plaintiff. So appearing for the defendant number 4 and 5. Counsel for the plaintiff prays for extension of time to file affidavit in opposition in connection with GA-Com 3 of 2025. That affidavit in opposition we filed within 2 weeks, reply if any there to be filed within a week thereafter. Please the matter on 22nd May.
20.
Take back.
Item number 18.
Milord, in item number 18, I am for the plaintiff, Milord. I am being led by Mr. S.N. Mitro, Milord. He is on his leg before court number 36, Milord. I am praying, Milord, if the matter can be taken up at 2, Milord. If the matter can be taken up at 2, Milord. At 2 p.m. Yes, ma'am.
Very well, Milord. At 2 p.m. Ready matter?
Yes,
It's a demurrer
Yeah,
application.
Milord.
I had my case, I've made my submissions. I said that leave under clause 12 was not asked for, part of cause of action. So, Mr. Mitra is supposed to reply.
Come at 2.
We will proceed.
Come at 2.
Item number 19.
Lord, in item number 19, Lord, I appear on behalf of the plaintiff respondent number 1. Lord,
The respondent number 4, Your Lordship.
we've served our opposition, but Lord, belatedly, Lord, I was seeking a extension of time to Lord file. It's ready. Lord, I can file it here and now.
You are appearing for?
Lord, the plaintiff in the suit, the respondent number
plaintiff.
1. Yes, Lord.
And
By
Mr. Kotari are for the 1 and 2.
defendant number 1 and 2.
And you are appearing for 3.
Respondent number 4, Your Lordship.
4. Who is 3? Pooja Shah.
Not your belief.
Lord, they were there on the last.
GA2 filed by you.
Your Lordship,
my learned
GA-Com 2
friend.
has been filed by me.
Ah.
Your Lordship, that application is seeking a direction upon them because when the writ of summons was served, the statement of truth and other documents which are required under the Commercial Codes Act was not served on us. So I have taken out that application with respect to that.
Only
To
that.
which, yes, Your Lordship. Only that, and I will show to you. I will try and convince Your Lordship that it is it is a mandatory provision under the Commercial Codes Act.
Correct.
So, Your Lordship, that, they have filed their affidavit in opposition to that application which was served upon us yesterday.
Yes.
Lordship, I would like
Lord,
to
I'm
use
out
a
of
reply.
time. Lord, note it down.
If they're out of time, Lordship, I would like to use a reply if Lordship grants me 2 weeks. The time was till 31st of March.
So appearing for the plaintiff. So appearing for the defendant 1 and 2. So appearing for the defendant number 4. None appears on behalf of the defendant number 3. Counsel for the
My Lord, I filed it today, my Lord.
Plaintiff has filed affidavit in opposition in connection with GA-Com 2 of 2025 after serving the copy of the same to the learned counsel for the defendant number 1 and 2. Let the same be kept with the record. Counsel for the defendant number 1 and 2, praise for time to file affidavit in opposition, affidavit in reply. Let affidavit in reply be filed within 1 week.
Lordship kindly gives me 2 weeks voluminous.
Lord, we've had to, my lord, I'll tell your lordship why, my lord. My lord, my learned friends have been contesting a separate litigation from which this suit arises. Lord, they have full notice.
Within 2 weeks.
Lordship, 2 weeks.
Within 2 weeks. List the matter on 14th May.
Lordship, just one indication in your lordship's last order dated 18th of March, your lordship had directed the plaintiffs to take appropriate steps as to whether writ of summons was served on the defendant number 5 or not.
My lord, kindly allows me some time, Lord.
Counsel for the plaintiff prays for extension of time to ascertain whether the writ of summons was served upon the defendant number 5 or not.
Lord, pro forma defendant.
Pro forma defendant.
Alter
Let,
ego of Mr.
let the said report be, let the said information be filed before this court on the next date fixed.
Deeply obliged.
Grateful, Lordship.
Item number 20, I appear for the defendant numbers 1, 2, 4, and 5. This is my application. Extension of time for filing the written statement. We are within 120 days. Suit was filed on.
You are for the defendant.
Defendant numbers 1, 2, 4, and 5.
1, 2, 4, and 5. Who has filed this application?
This is my application for extension of time to file the written statement. The suit was filed on 23rd of September. The writ of summons was served upon me on 21st of November 2024. It was made returnable on the 6th of December. Your lordship, I am beyond 30 days, but within 120 days, I filed it on 12th of March.
When you filed the written statement?
12th of March.
Where it is?
Your lordship, it is there. We filed it with the department, but we're just seeking leave for your lordship to accept it.
It is filed?
It is filed with the department, your lordship.
You have not taken the back page of copy
Yes, your
of the
lordship,
back
that was
page?
there.
Where is that? Otherwise, I have to call for the report. For
No, your lordship. That is
yes, what is your submission?
Apologize.
Explanation can be written there. Started the 2nd December. They were sitting idle till 2nd December.
All defendants are sitting idle after receipt of summons. They woke up only after 90 days.
90 days.
Your lordship, I apologize. That is
not there.
The endorsement by the department is not there. Just my senior is here. He will just indicate to you.
Census suffering for the plaintiff, census suffering for the defendant number 2, 3, and 4. 1, 2, 4, and 5.
1, 2, 4, and 5.
Full stop. The defendants 1, 2, 4, and 5 have filed an application being GA-Com 1 of 2025, praying for extension of time to file written statement. Counsel for the defendant number 1, 2, 4, and 5 submit that they have filed the written statement with the leave of this court in the department on 10th of March, 12th of March 2025. In view of the above, the department is directed to submit the report whether the defendant has defendant number 2, 4, 2, 2,
1, 2,
1,
4,
2, 4, and 5 have filed the written statement on 12th of March or not. Within a week, list the matter on 28th April 2025.
Very grateful to you, lordship.
Item number 21. Your lordship's pleasure, my lord, to pass it over once, my lord. The learned counsel appearing, my lord, he is on legs, my lord, in courtroom number 16, my lord.
What is the matter?
This is an amendment application, my lord.
Who is for the defendant?
There was a direction for filing affidavits, my lord, on 11th of March. They did not, my lord, at the last occasion, my lord, on 4th of April, the matter came up before your lordship. Nothing was filed, so your lordship said, my lord, on the next day, if they do not appear, then orders will be passed. My lord.
What is the amendment?
My lord, the amendment is, my lord, some debit note. My lord, this was for money.
You want to bring on record?
To bring on record, my lord, 2, 3 documents, my lord. That was missing at the time of filing, my lord, because the person dealing with the documents was indisposed. So he, at the day of filing of the suit, my lord, he was not available. So, my lord, we filed the documents. We filed the suit, my lord, without those documents. Thereafter, when we were moving the judgment upon admission application before your lordship, my lord, your lordship directed, my lord, the amounts raised. The bills raised and the money received and the outstanding was not tallying. It is then it struck us, my lord. Then we, my lord, went back and when we saw, my lord, there was a defect in the, my lord, in the application, my lord.
Nobody is there.
Nobody is appearing, my lord. If your lordship takes it up at 2 p.m., my lord, it will hardly take, my lord, 5 minutes.
Not today.
Not today. I'm grateful.
Yes, next.
My application, your lordship, for judgment upon admission. Should we have served the copy to the other side, your lordship?
But I appear for the defendant. I want to file my affidavit.
So judgment can be passed.
Judgment so far as affidavit.
Admitted claim, your lordship. If we can
Well,
take instruction, your lordship, how will
No,
pay?
no, we have taken instructions. Malad, our client also wants to settle. I'll say that Malad will not record anything per se. We also want to settle.
Then
It's
let
for
me
price
come
of
back
goods.
on Monday.
No, no.
So what do you want?
Malad, I want to file affidavits to this application at present. Malad. My client is in the meantime Malad, trying to settle the matter.
I will record. You want to file affidavit in opposition by admitting the claim.
No, Malad. Malad, we kindly allow me to
Lordship,
file
if he can come back on Monday.
Our client Assam. I have to communicate.
Who is
My
this?
client is my client is in Assam. Malad. Malad, let me file my affidavit Malad, formally.
Then
I have also
Mr. Dasgupta is of the view that before vacation it is settled, it will be better for him.
Well,
Malad,
if
we are
he
trying
files
our
an
best.
affidavit, I'll place for the interest.
So of course, interest he is
So
already
sensation
facing.
suffering for the plaintiff, sensation suffering for the defendant, sole defendant.
Sole defense.
Counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition file by 2 weeks.
Malad, 3 weeks if it comes similar because he's based in
3
Assam.
weeks reply if any there to be filed within a week thereafter. List the matter on 20 May.
20.
Oblige.
পরে দাও না এটা কি দিয়েছো
Affidavit of service.
affidavit of service and motions will
Affidavit of service and
notice of motion here.
and notice of motion be kept with the record.
I'm grateful.
Nobody is there. Not today.
But I'm for the defendant. Oh, sorry.
24. Yeah. Who's for the plaintiff?
My lord, I am for the plaintiff.
Yes.
My lord, kindly grant me an extension of 2 weeks, my lord.
For?
For filing
The
affidavit.
matter is all of
Me,
matter.
I appear for plaintiff. There was a direction for filing affidavit in opposition to the application filed by my learned friend for condemnation of delay for filing written statement for 3,000 something days. Millard, due to illness, Millard, my illness, Millard, it could not be filed. Millard, I am praying.
You are appearing for whom?
I am appearing for plaintiff. Millard, I am praying that extension of time to file my affidavit in opposition.
So they filed an application for extension of time to file written statement.
Yes.
Condoning the delay.
Yes.
Of 3,000
3,000 something days.
3,200. Okay.
Well, may I submit? Well, this matter was transferred to the commercial court. Now they have been directed to file their statement of truth, affidavit documents on the last occasion, on 17th of March. So my lord, kindly take up the order date 17th March. So they haven't filed yet. And it is probably a third or fourth occasion they are praying for time.
No.
Yes, I can indicate from the order sheet, my lord. My lord.
Not correct, my lord.
Yes. Absolutely.
Lord,
There was a
suit
correction.
was transferred in the month of January, my lord.
No,
This year.
the suit was transferred, my lord, on 13th December. 13th December 2024, my lord. The order dated 13th December.
You filed the application for extension of time in the non-commercial matter division or the commercial division?
We filed an application for condonation of delay of filing the
division or
non-commercial division.
On the last day when the suit was transferred from non-commercial to commercial, they have filed this application.
We have? Sorry? I have filed my application before the non-commercial.
Non-commercial.
And later on by order
It is-
dated 13th December, my lord,
My lord,
it was
correct.
transferred to the
I am not
commercial
disputing
division.
that.
Now they have to regularize the application. They have to file the statement of truth. They have not done that.
Yes.
Well, I have stated that due to my illness,
That's correct. That's see the circumstances and consider the Commercial Court Act. It is in the non-commercial division. Correct. Non-commercial division, he has not filed an application. He has not filed the written statement. He filed an application for condoning the deed. But subsequently, the court transferred the matter to the commercial division in the month of March.
In the month of December,
December
13th December.
2024. By that time, the application for condonation of delay is on record. Correct. But as per the act, if it has been sent to the commercial division, then you have to take appropriate steps for amendment and filing for amendment in the plaint as well as order this list of documents and all
Statement of truth.
all the things. If it is then new timeline is to be granted to the defendant to file the written statement.
My lord.
This is
Consider that.
Yes, I leave it to.
Consider that. Sensation suffering for the plaintiff, sensation suffering for the defendant. Counsel for the plaintiff prays for extension of time to file affidavit in opposition in connection with GA 3 of 2024. Let affidavit in opposition file within 2 weeks. Reply if any thereto be filed within
2 weeks.
2 weeks thereafter. List the matter on 21st of May 2024.
But so far the instruction of the statement of truth, they have
will take. If it not take they have to face the consequences. The commercial suit, they have to take.
I'm grateful to.
My lord takes up item number 25. I missed item number 23. I'm 23, my lord. I'm appearing for the respondent plaintiff. My lord, this was an application taken out by the defendant for extension of time to file the written statement. Now, my lord, on last occasion, an order was passed directing the department to file a report as to when the service of summons was affected and when they entered appearance. My lord, if that report has come, kindly permits us to take a copy of it. My lord, one line order, if my lord kindly permits us, then we can just take a copy.
Record an order in item number 23.
My lord, may direct the parties to take copies. I don't want to take a copy individually.
In terms of the order passed by this court, the registrar in charge of commercial division has filed the report. Full stop. The department is directed to supply the copy of the report to the land council appearing for the parties within a week from date. List the matter on 29th April 2020.
I'm extremely grateful to man.
I appear for the plaintiff, my lord.
Lordship, I'm appearing for the defendant. I'm being led by Mr. Rupak Ghosh in this matter. Lordship, he's not in court today. May your lordship
The
not...
issue, my lord, that is that, my lord, is that, my lord, this instant application is my application, my lord.
For what?
My lord, seeking to, my lord, direct the Kolkata Municipal Corporation to supply some documents which, my lord, the defendant has refused to give to me. My lord, the application, my lord, is, my lord, otherwise ready for your hearing. My lord, the opposition, my lord, has been served. My lord, a reply is ready as well. My lord, if both can be taken on record and the matter be fixed next week, my lord, the GA5, my lord, for rejection of plaint is already fixed, my lord, on 23rd.
Reply in which
My lord,
application?
GA4, my lord.
GA4 is for what?
My lord, for supply of documents. My
Supply
lord.
of documents.
Yes, my lord. My lord, GA5 is listed on the 23rd of this month anyway, my lord. If, my lord, both of them can be taken up together, my lord. Yes, my lord.
By which order?
My lord,
Lordship,
by
as
the order
per 4th April's order, your lordship, all the GAs were fixed to be heard on 23rd April.
Correct.
Yes,
not just GA5, your lordship. The lordship kindly doesn't take it up today, your lordship, Mr. Rupak.
My lord, the opposition, my lord. My lord, the opposition and replies are ready, my lord. If they may be taken on
file my
record.
opposition.
Sensation suffering for the plaintiff, sensation suffering for the defendant. Affidavit in opposition and an affidavit in reply in connection with GA4 of 2025 filed by the parties be kept with the record. Let the matter appear on 23rd April.
Grateful, my lord.
Grateful, lordship.
My lord, if, my lord, I may make one small indulgence. My lord, item number 28, my lord. My lord, is a small application, my lord, for amendment in a different suit.
Let
My lord,
the matter.
27, my lord. Grateful.
Item 20.
Next.
Lordship, may I be permitted to appear virtually, Lordship, in item number 26, Lordship?
Yes.
Your
I am
lordship,
for the plaintiff, Lordship.
I am
Lordship, it is my application, GA Com 3 of 2025, Lordship.
lordship, I am led by Mr.
Extension
Shoma
of
because my lord, he is having some difficulty. Only I'm praying some.
Yes.
Lordship, this is my application for extension of time to file my written statement, Lordship. The counterclaim was served on me on 6th January, Lordship. I'm within 20 days. Written statement has been filed before the department, Lordship.
Okay, the plaintiff is asking time, defendant is asking
Not
time.
today, your lordship. Only not today, your
Not
lordship.
today. Come
Lordship
tomorrow.
will just kindly extend the time to file my written statement, Lordship.
No. This is to be heard.
Lordship.
Lordship kindly keeps it on
As
20th.
per the prayer made by the counsel for the defendant, let the matter appear tomorrow.
Your lordship, 23rd of April.
Let the matter appear on 24th April.
Your lordship.
Lordship, I'll be over.
I'm
My lord, this is my application for amendment, my lord, of the plaint. There's certain innocuous amendments that we are seeking for, my lord. It's ex parte, they have not appeared. Your lordship had passed an injunction. We have served the injunction. Thereafter, on the last occasion, we had pointed out that there's certain innocuous amendments that we wanted to carry out. So, your lordship said that take out an application and it will be better. My lord, the application is now here before your lordship. My lord, page 14 onwards is the amended plaint. I shall just take your lordship with the... It starts at page 20. Yes, I know. 1 second.
In the plaint, you want amendment.
Yes.
What you reply and what is the what which is reflected in the proposed amendment?
Yes, my lord. The
This is
proposed
the-
amendment has been annexed, my lord, marked in red ink. My lord, if your lordship takes the concise statement at page 13, my lord, that will be 6 crore. That has become lakh.
Have you served the have you given the copy to your client?
No, not
This plaint was served to your client before amendment.
No, not this. No, this was a mistake on our part.
Otherwise, you have to bear the medical expenses of the plaintiff.
Absolutely. My lord, this 6 lakh, 6 crore, my lord. Thereafter, if your lordship straight away comes to page 24, page 24 and 25, my lord, these are minor corrections, my lord. I would say minor corrections. Your lordship can go through them, my lord. These are 2 paragraphs where we mentioned defendant. It would be ex-employees of the plaintiff. Because there was not only one defendant, but there were several other ex-employees. So, my lord, 24 and 25 are the corrections to that effect. Thereafter, my lord, if your lordship takes 36.
Again 6 crore.
Prayers is again that medical issue of that. And 38. Lord, this was the reason why your lordship said that carry out the amendment application. 38, 39 and 40.
So and so appearing for the plaintiff. The plaintiff has filed the present application praying for certain amendments in the plaint. Had the learned counsel for the plaintiff peruse the proposed amendment, this court find that the amendment as sought for by the plaintiff is formal in nature and will not change the nature and character of the plaint. Accordingly, prayer A to F. F of the master summon is allowed. GA Form 2 of 2025 is disposed of. 2 of 2025 is disposed of.
My lord, the interim order is expiring on 25th, my lord, if your lordship. We have served, they are not appearing till date, my lord.
Come on 25th, mention it. Otherwise,
Keep
they will come and say. Okay.
Lordship, the next item was item 28 actually.
28 is the adjourn motion. Come tomorrow.
Yes, sir.
हाँ? कहाँ से लाया? Yes. But it's mentioned in the morning, na?
Item number 18.
Yes. 18 is
But I have made my submissions on the temporary application.
Singh has made his submission. Malad. But their application, Malad, praying for Malad. Dismissal of our suit on the ground that we have not taken the leave necessary. GA नहीं है. GA number? But the GA number is IAGA number কত 2 4. No. Just শুরু করছি. GA2 IAGA number 2. GA number 2 is for? But GA number 2 is their application, my lord. But GA number for my lord dismissal of the plaint on the ground, my lord, that we have not. You are ready? Yes, my lord. Kindly see the GA2. What is the prayer?
What হবে their application?
Pass থেকে what tree? Order 12 rules.
Next week group 6 কেন আগে?
না 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 ওই অ্যাপ্লিকেশনটা বলছি. Yes. GA4, my lord. My lord, I'm ready. Led by Mr. Mitro, my lord.
Sorry, my lord.
Yes, sir. Continue.
My lord, kindly take up their application. Their application is, my lord, for revocation of leave granted under clause 12 of the latest patent. That is IGA4. That, my lord, according to me, is required to be heard first, because if the jurisdiction goes, my lord. Sorry. Dismissal of the
rejection of plaint.
Rejection of the plaint because this court has no jurisdiction.
No jurisdiction.
I'm sorry. Yes. Now, my lord, kindly look into their petition, my lord. What is the case made out? My lord, kindly come to my lord. Page, my lord, 7, paragraph 5. I say that the following averments transpiring from the plaint and the documents annexed there to demonstrate that a significant part of cause of action of the instant suit has arisen outside the jurisdiction of this honorable court. This is one. So, my lord, they say that, my lord, a significant part of the cause of action has arisen outside the jurisdiction. Then kindly come to the next paragraph, my lord. Kindly omit the subparagraphs. Kindly come to page 9, paragraph 6. I say that it is a trite law that if the territorial jurisdiction of this honorable court is invoked, not on the basis of citus of the defendants, not on the basis of citus of the defendants, but on the citus of the cause of action, even if an infinitesimal part of the cause of action is seen to have arisen outside the territorial limits of this honorable court, without previous leave under clause 12, no suit can be instituted. Then, my lord, kindly take up, my lord, the next, paragraph 7. I say that it clearly transpires from the plaint that despite having substantial cause of action, beyond or outside jurisdiction of this honorable court, the respondent has failed to pray for and obtain leave under clause 12. And my lord, then paragraph 8 that no leave has been obtained. This is the case. Now kindly come to the plaint, my lord, whether my plaint is on the basis of the cause of action or my lord something else. My lord, kindly come to page 17. Kindly come to page 17.
Yes.
Forget about the plaintiff, my lord. It can be anywhere. Kindly come to the defendant number 1, Amit Banijjo, having his registered office at such and such outside jurisdiction as aforesaid, and office also at Siddha Park, 99A Park Street, room number such and such within the jurisdiction. Same is, my lord. Kindly come to the defendant number 2 and 3, same pleading.
Yes.
That they are, my lord, all the 3 defendants are both within and outside. Now kindly come to, my lord, the averments. I shall go through. It's a small plaint. I shall go through it, my lord, very quickly. Kindly omit paragraph 1. Kindly come to, my lord, paragraph 2. The defendant number 1 is a private limited company existing under the provisions of the Companies Act, having its registered office at such and such, and managing, operating, and conducting its business from its office at Siddha Park, 99A Park Street, room number such and such within the jurisdiction aforesaid. Kindly come to the next paragraph. Sometimes in or about October 2015, the defendants, for the purpose of expansion of their business, approach the plaintiff at its registered office situated within the jurisdiction aforesaid. It's a cause of action part. Then kindly turn the page. Page 4. The loan amount was advanced, disbursed, and or made over by the plaintiff in favor of the defendant number 1 with a check number such and such, drawn on Karnataka Bank, Overseas Branch, first floor, Sarojini Naidu, Saroni, situated within the jurisdiction as aforesaid. The defendants had received the said check at the office situated at 99A Park Street. Then kindly come to, my lord, the next. The defendants have availed the said loan amount and duly received the same in their bank account without any demur or protest and utilized the same. The aforesaid loan transaction was also confirmed, admitted, acknowledged, and accepted and acknowledged by the defendants via a communication letter dated 5th October 2015 from their office situated at 99A Park Street, etc. Now kindly come to this letter at page 36.
Page
36.
Yes.
The defendant number 1 writing. The top left hand side, lordship will find the name of the defendant number 1. Kindly look into the address on the right.
Park Street.
Siddha Park, Park Street. Then, my lord, kindly come back to, my lord, page 21. Paragraph 6. The plaintiff states that owing to the financial constraints as represented by the defendants, from time to time, the plaintiff has extended the period of repayment of the said loan amount, which was lastly extended up to 30th September 2020 on mutual agreement by and between the parties herein. During such extension, the rate of interest was understood to be enhanced mutually between the parties herein with effect from 1st April 2017. From 12% per annum to 14% per annum. It is pertinent to mention herein that each and every renewal of the repayment schedule is repeatedly acknowledged by the defendant via several communication letters issued from time to time in favor of the plaintiff in acknowledgement of their liability to repay the loan amount. Inter alia, the defendants also had taken aback the previous checks and tendered other checks in exchange of former checks in favor of the plaintiff at its office situated within the jurisdiction as aforesaid. Now, this, your lordship, will find, my lord, from page 38 onwards. (38 to 50), all these letters, all, my lord, issued from their office at Siddha Park, Park Street. Lordship can take it from me, my lord. 38 to 50, my lord, all are from Siddha Park. Then, my lord, kindly come back to, my lord, Page 23, my lord, paragraph 9.
Yes.
That in the event of such dishonor, plaintiff caused a notice of demand dated 12th November 2020 sent to the defendants through its learned advocate under speed post, thereby intimating the defendants about the fact of dishonor of the said check and demanding the said sum of rupees 1 crore 3 lakhs, covering the amount in the said checks. The said notice has duly been served upon the defendants. Copy of the said notice dated 12th November 2020 along with postal registration. Kindly come to page 59.
Yes.
Kindly come to page 59. It is sent to my lord Siddha Park as well as to agency post. Then my lord, kindly come back to page 23.
Yes.
After the issuance of notice dated 12th November 2020, the plaintiff gave another notice dated 25th November 2020 with an impression of commission of certain typographical mistakes in its first notice dated 12th November 2020. However, the first notice dated 12th November 2020 was replied by the defendants by their letter dated 28th November 2020. However, the defendants did not reply to the second notice dated 25th November 2020. A copy of the said notice dated 25th November 2020 and 28th November, that is their reply.
Yes.
Along with the postal track records. Now kindly come to page 71.
Yes. Old Post Office Street.
And ballot to Shantanu Kumar Roy,
10
10 Old Post Office Street. Reference your client, Anubandh Financial, 111 Park Street. Yes. Now kindly also, my lord, come to, my lord, the first paragraph of that letter at page 71. Your letter number such and such dated 12th November 2020 sent on behalf of your aforesaid client to my client, Amit Banijjo and Rajendra Saragi, etc. Director of Amit Banijjo Private Limited, both having their office at Siddha Park, 99A Park Street, room number such and such. PS Park Street has been made over to my office. And then, my lord, kindly come back to the plaint once again. Paragraph 12, my lord, page 24 speaks about a complaint case. It's not required. Then kindly come to page 26, my lord. It speaks about steps taken under section 12A.
Yes.
Paragraph 19, my lord.
Yes.
Then kindly come to paragraph 20, my lord. This is the paragraph. The cause of action of the instant suit has arisen on several dates, including on 31st October 2020 and 3rd November 2020, when the plaintiff presented check number such and such, both dated 1st October 2020, drawn on RBL Bank Limited, as pleaded in paragraph 8, with an expectation of encashment of the same as per the assurance of the defendant, and also respectively on such and such, when the said checks were reported to be dishonored and returned by the concerned bank with remark fund insufficient from the office situated at Park Street branch, Kolkata, within the jurisdiction aforesaid, and on 12th November 2020, when the plaintiff caused notice of demand to be issued upon the defendant and reply thereof, received the letter dated 28th November 2020 from the defendants through their advocate, when the defendants through their advocate have replied the demand notice of the plaintiff and wherein had duly acknowledged and admitted the claim of the plaintiff, however denied to make payment thereof. And lastly, on 31st January 2021, when the defendant further made payment of interest in acknowledgement of the principal amount. It is well settled that in computation of the period of limitation under any general law or special law, the time period between 15th March 2020 to 28th February 2020 is liable to be excluded for the purpose of calculation of the period of limitation in view of the order passed by the Honorable Supreme Court in Suometo case number such and such. Therefore, including the claim of the plaintiff as made in the instant suit is within the period of limitation. No part of the cause of action in the suit is therefore barred by limitation.
Yes.
This paragraph, my lord, does not speak about any cause of action. Now, my lord, I have proceeded on the basis, or the plaintiff proceeds on the basis that, my lord, the defendants have their office both within and outside jurisdiction. Hello, na? My lord, kindly, my lord, if your lordship has, my lord, the original side rules, my lord. No, kindly, my lord, my junior has a soft copy of it and clause 12 bar kore eta ki 24-25 ki latest patent. Kindly look into, my lord, the latest patent, my lord, clause 12.
Yes.
Kindly give me a minute still. Hey, দে ওটাই দে, এটা কি বই আনবে না পয়সার জন্য লাফিয়ে বেড়াবে। But kindly look into, my lord, clause 12. And we do further ordain that the said High Court of Judicature at Fort William in Bengal, in the exercise of its ordinary original civil jurisdiction, shall be empowered to receive, try and determine the suits of every description. If, in the case of suit for land or other immovable property, such land or property shall be situated, or in all other cases, if the cause of action shall have arisen, or the defendant at the time of commencement of the suit shall dwell or carry on business or personally work for gain within the local limits of the ordinary original jurisdiction of the said High Court, except that it shall not have such original jurisdiction in cases falling under the jurisdiction of small causes court, etc. It's not important. It does not say that it carries on business. Kindly come back to that portion, that defendant at the time of commencement of the suit shall only dwell or carry on business.
Yes.
It has to have, my lord, its residence or business place within the jurisdiction. That is the requirement, and the entire suit, my lord, proceeds on that basis.
Yes.
The paragraph, my lord, which I had placed, the lastly, paragraph 20, it deals with only the question of limitation.
Correct.
It does not say that a part of the cause of action arose within and a part of cause of action arose outside, and that is why leave is required.
Yes.
Now, my lord, in that view of the matter, my lord, in my respectful submission, their application for rejection of plea in that view of the matter, my lord, in my respectful submission, the suit has been framed on the basis that, my lord, the defendants, all of them, carry on business both within and outside, and, my lord, or, as I have submitted, my lord, latest patent clause 12 does not say that it has to be the only place. In view of that, my lord, in my respectful submission, the application, my lord, is bound to fail, and, my lord, should be dismissed. Those are my explanations.
Thank you.
Reply.
Nothing much to reply. No. Only on one aspect, my lord, I put my reply in the form of a question, my lord. That if the plaintiff wanted to institute this suit in Alipur court, my lord, commercial court, whether the plaintiff could have filed it or not. This is a question, my lord, because the defendant's office is in AJC Bose Road, admittedly outside the jurisdiction of this honorable court. series of my lord facts which are a part of the plaintiff's pleading appear show, my lord, that the defendant was notified about the dishonor of check. The defendant was called upon to make payment from that office. Well, whether the plaintiff could have filed a suit before the Alipur court, my lord, or not, is the question on these facts, my lord. If the plaintiff could have instituted a suit in the Alipur court, then part of cause of action was in fact outside, and therefore leave is necessary, my lord.
But the letters correspondences are with the Siddha Park and both addresses.
Yes, part is within. I'm not disputing. Part is within, and my lord, Justice Sanjeev Banerjee has used an expression, my lord, infinitesimal, my lord. It's a tongue twister, my lord. How no any part of cause of action, however small it is, my lord, if it is outside, then leave is necessary. Now, my respectful submission is, my lord, no matter how small it is, a part of his cause of action is outside. Because it's not only that defendant carries on business, my lord, repeated demands were made to make payment, and the failure on the part of defendant to make payment from that office also was a part of cause of action. And had the plaintiff
Where is that?
notices that those are all part of the.
That's why the
I had
notices
showed, my lord,
kindly
the
come to
plaint.
Page 59.
My lord, I had shown the plaint.
Yes.
Paragraph, my pleadings at paragraph 5 that summarizes my case, my lord, which has reference to the paragraph numbers of the plaint also, my lord. But these notices, letters, all were addressed to AGC
Both
Post Road.
address, both address.
Both the address.
Both
Yes,
address.
yes, both the addresses.
Correct. Both address.
So, my lord, if I am able to, my lord, demonstrate that part of cause of action was outside, then leave is mandatory if a suit has to be instituted before the original side of this honorable. And on these facts, my lord, I think part is outside. If part is outside and no leave is sought, the plaint has to go, my lord. That's the short point that I've made, my lord. My lord will decide, my lord.
Okay.
My lord, as I have submitted, there is no point in repeating.
Okay. So appearing for the plaintiff, so appearing for the defendant. Defendant has filed an application being GA Com 4 of 2025. Praying for rejection of the plaint. Hearing concluded. CAB. Yes, next.
My lord, the other applications will appear. There is an application under Order 12, Rule 6.
After this?
Yes, after that.
Let it decide.
Yes.
वो पासवर्ड वो है ना फिक्स मैटर करो फिक्स मैटर नहीं है ना नहीं होगा डिसमिस कर देगा
I apologize, Murad.
Okay, no problem.
Inadvertent.
Item number 2, number is there. None appears in behalf of either of the parties, even on the second call. The matter is listed today as especially fixed matter 2 p.m. for witness action on behalf of the plaintiff. Full stop. In spite of full stop. When the matter is called, none appears, none moved. Accordingly, the case is adjourned. Accordingly, CS Com 673 of 2024 is dismissed for default. Item number 28. You had the urgent when I was leaving. Now nobody is there. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of June 2025. Combined, none appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of June 2025. None appears, same order. None appears, none moved. Combined monthly list of June 2025. Number 30.
Lordship, I'm for the petitioner. The writ of summons has been issued.
I'm appearing on behalf of the defendant, my lord. I'm led by Mr. Amarjeet Kumar, my lord. He is also joining in, my lord.
Yes.
Lordship, in this matter, the learned senior had made his submissions on behalf of the petitioner, and we were to make our submissions on behalf of the defendants, my lords, respondents. And,
Yes.
my lord, as I said, my lord, I'm led by Mr. Amarjeet Kumar, my lord. He's just joining in, my lord. He's appearing online, and he's just joining in, my lord. And, my lord, first of all,
No one is there on the line. Paso.
and grateful.
Next.
31, my lord, I appear for the defendant. We had filed an application, my lord, seeking recall of lord's order whereby the writ of summons was waived. I will recall this matter was argued at length. I was being led by Mr. Shumon Dutt.
Yes.
Lord, we had concluded our arguments, my lord. Two judgments
the
were
other
handed
side?
over. They were in the midst of their arguments, the plaintiffs. Mr. Chatterjee was there. Not here, my lord.
Surya Prasad Chattopadhyay.
I can inform him, my lord. I'll give him a call if my lord passes it over.
Paso. Next.
That I'm for the plaintiff petitioner, my lord. Our order 12 rule 6 application, my lord, we had argued that the defendants were replying, my lord.
Who is for the defendant?
That Mr. Soroshi Dasgupta, I'll inform him. He was there having lunch, I believe.
Huh?
He was there, my lord. I believe he is on his legs. I'll
Paso.
just inform.
Next.
33, I am for the plaintiffs, your lordship. There are several applications filed by both the plaintiff and the
I'm
defendants.
for the respondent number 2 and 3.
Lordship, I am led by Mr. S.N. Mukherjee, senior advocate. If this matter could be posted to any time in May, your lordship.
You are appearing for?
Plaintiffs, your lordship.
Who is for the defendant?
I'm for respondent 2 and 3.
2 and 3. So much lengthy order than release.
Lordship, one application was disposed of, being GA9.
But I appear for the legal heirs of the deceased plaintiff. But GA8 has been filed by one of the defendants. GA8, I believe, but no one is appearing on behalf of the applicant in GA8.
Who has filed the GA8?
Lordship, I'm appearing for defendant number 1. I am the applicant in GA8.
GA8.
Lordship, I'm seeking for an accommodation, Lordship. Lordship, Mr.
How many applications are pending? GA8, GA9?
Lordship, GA9 is not pending. GA8.
10, 11 is also pending.
10 and 11.
GA9 is
All can be taken up in May. Kindly give
All
some
may be
date.
taken up in May, Lordship.
No, what is the, how many applications are there?
4, I think.
7, 8, 10 and 11, your lordship.
7, 8?
10 and 11.
मनोज कितना चाहिए इसमें? Item number 33.
One, there is GA4 also.
So appearing for the plaintiff. Legal heirs of the plaintiff number 1.
Lordship, plaintiff number 1 has expired.
Hmm.
His legal heirs are separately represented, Your Lordship. I am representing.
Substituted.
No, they have not been. The substitution application is GA8, which is pending, Your Lordship.
So appearing for the legal heirs of the plaintiff number 1. So appearing for the plaintiff number 3. So appearing for the defendant number 1. And so appearing for the defendant number 3 and 4.
2 and 3.
2 and 3. And it is fine from the record. There are altogether 4 applications are pending, being GA number, being GA 4, GA number 7, GA number 10, and GA number 11.
GA number 8 also.
8 also.
It is not on GA number.
8 is there. 8 is there in the list.
GA number 4, GA 7, GA 8,
10 and 11.
10 and 11. Okay. Let, as per the prayer made by the counsel for the respective parties, list the matter on when 16 May.
Yes, my lord.
My lord, I'm for the defendant number 1. G8 is my application.
On 16th May 2020.
Grateful.
Led by Mr. Pranit Bagh.
Okay.
Grateful.
16 May. Next.
Number 34.
16 May. Yes, next.
Number 34.
My lord,
one indulgence, my lord.
Sorry.
My lord, I was fall down, my lord.
Item number 34. Who is
My lord, while running, my lord, I was fall.
is appearing item number 34.
Lordship, item 34, I am for the respondent, Lordship.
Who is for the plaintiff? Nobody. None appears on behalf of the plaintiff. So appearing for the defendant number 2. For the interest of justice, the case is adjourned. Let the matter appear on 22nd May 2025. Next. That is it. None appears on behalf of record and order. None appears on behalf of either of the parties. No accommodation is sought for. It is fine from the record. The matter was listed on 5th November 2024 and on the prayer made by the counsel for the plaintiff, the case was adjourned. Again, the matter was taken on 23rd of December 2024 on the said date also on the prayer of the defendant on the prayer made by the counsel for the plaintiff, the case is adjourned. Today when the matter is called, none appears on behalf of the plaintiff, no accommodation is sought for. Accordingly, CS Form 291 of 2024 within bracket old CS 152 of 2024 is dismissed by default. Consequently, the interlocutory application is also dismissed. Next. None appears on behalf of either of the parties. Let the matter placed in the combined monthly list of June 2025. Next. None appears same. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear combined in the combined monthly list of June 2025. Next.
My lord, item number 38, I'm appearing on behalf of the plaintiff petitioner in this matter. My lord, GA3 has been reserved for orders vide order dated 30th November 2022. And my lord, GA2, which was basically an application seeking for judgment upon admission, has been vide the order dated 30th January 2023. The matter was taken out of the list with liberty to mention since GA3 is pending. So, my lord, we have already mentioned the matter before Justice Arinda Mukherjee, who had heard the matter at length, my lord. The judgment is yet to be delivered, my lord.
As per the prayer made by so appearing for the plaintiff, as per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear in the combined monthly list of June 2025.
Obliged, my lord. Grateful.
Next. None appears on behalf of either of the parties. No accommodation is sought for. According CS Com 333 of 2024 is dismissed for default. Interlocutory application, consequently, interlocutory application is also dismissed. Next. None appears on behalf of either of the parties. No accommodation is sought for. Accordingly, CS Com 337 of 2024 within bracket old CS4 of 2022 is dismissed for default. Consequently, all interlocutory applications are also dismissed.
My lord, I appear on behalf of the defendant.
Who is for the plaintiff?
Nobody is appearing.
None appears on behalf of the plaintiff. So and so appearing for the defendant. For the interest of justice, the case adjourned. Let the matter appear in the combined monthly list of June 2025.
Yes,
My lord, the advocate on record for the plaintiff has requested me, my lord, to only pray for a not today, my lord. She's, my lord, had to leave court on an emergency, my lord, only not today.
Not today.
Obliged.
Next. None appears on behalf of either of the parties. No accommodation is sought for. Accordingly, CS Com 426 of 2024 within bracket old CS 224 of 2022 is dismissed for default. Consequently, interlocutory applications are also dismissed. Next.
Plaintiff. My lord, I'm appearing on behalf of the plaintiff.
in item number 43, Your Lordship. I'm being led by Mr. HON'BLE Ghosh. He is not present in court today.
When the last matter was heard? See the last date of the hearing of the case.
I understand. Your
And the matter is listed here.
I understand. Your
So the
Lordship.
court will not wait for you.
The parties are in the process of.
Since February 2022, matter is pending.
Lordship, I apologize, Your Lordship, for my
So?
delay. The parties are in the process of getting into a settlement agreement, Your Lordship.
Get settled, dismiss, get it settled.
Lordship,
Dismissal will not.
Kindly grants a short accommodation, Lordship.
For what?
Lordship, we will file a settlement agreement before the court, Your Lordship.
Come with the settlement. Come, you settle that. I am dismissed. You settle and entered into an agreement between the parties.
Lordship,
What is the
kindly-
necessary to keep the matter pending here?
Lordship,
February 2022, the last order was passed. Subsequently, you are not neither you are appearing nor mentioning. When the matter is listed, now you are asking for telling that the matter is going to be settled. 3 years you have not settled the matter.
Lordship, I bow down to Your Lordship's indications, Your Lordship. Maybe may a
Cut the order.
short accommodation may be
As per the
granted.
prayer, so and so Supreme Water card then. So and so Supreme for the plaintiff. For counsel for the plaintiff prays for time. For the interest of justice, the case is adjourned. Let the matter appear in the combined monthly list of June 2025. Next.
Deeply obliged, Your Lordship.
Lordship, I am appearing for the defendants in the matter.
I'm appearing for the plaintiff in this matter, Your Lordship. I'm being laid by Mr. Devraj Rao and Senior Advocate Aniruddha Mitra, Your Lordship. He's not available today.
Okay, I am dismissing. When all the advocates will available, come with an application with the restoration. On that day, I will take up the matter.
Your Lordship,
That will be better. I will dismiss. You come with the restoration application with the condition. I will restore the application if the parties are ready to argue the matter.
Unconditional apology.
Not what apology. The list is published on when?
I understand what is falling from Your Lordship, Your Lordship. Only not today, Your Lordship.
So and so suffering for the plaintiff. So and so suffering for the defendant. So and so suffering for the plaintiff. So and so suffering for the defendant. Counsel for the plaintiff prays for adjournment. For the interest of justice, case is adjourned. Let the matter appear on 21st of May 2025. Next.
I'm grateful.
My lord, I'm appearing on behalf of the petitioner, Your Lordship.
Yes.
I'm being led by Senior Advocate Mr. Moti Sagar Tiwari, Your Lordship. He is on his legs before courtroom number 28.
Counsel for plaintiff have concluded his argument. Defendant, who is for the defendant?
Lord, I
Yes.
Lordship, I'm praying for a short Passover.
This was. I can start, my lord, if Lordship.
Mr. Tiwari has concluded his argument, madam.
I will also not take much time to conclude, my lord. This is that Order 12 Rule 6 application. I will take only 2 points if Lordship is satisfied.
That one.
Yes. If Lordship is satisfied, I have something, my lord. Otherwise, my lord, I'll leave it there.
Okay, not today.
Very well.
Come tomorrow.
Monday, my lord, in that case.
Okay, Monday.
Much obliged, Your Lordship.
Or I can complete and Mr. Tiwari can come on Monday, whichever way Lordship wants.
Come on Monday.
Very.
My lord, this was the Lordship was hearing this part heard application filed by the defendant under Order 7. Mr. Abhijit Mitra was leading me that specific performance of the development agreement vis-a-vis the power of attorney. Mr. Mitra was in the process of showing some cases. We had given a compilation of the judgment, that matter.
Yes.
Can we come on Monday, my lord? I am virtually.
You persons know the matter is listed again.
Yes,
Again.
no,
all are taking the time on the ground of the senior.
No,
So I will henceforth I will tell that the door will be closed. Only senior will be entered. Junior will not be entered.
Man, I will just.
You are also senior. You are also
Man,
senior.
I have a matter fixed. Man, I am virtually before another High Court with matter.
I will take the hearing from virtual mode.
In that case, let me start, man.
I am dismissing it. Sorry.
No, I am starting now. Let me allow to take the
Started.
judgment.
And you have to conclude.
I will try my best, my lord. Kindly pardon
All
me.
persons are playing with the court.
No, man. We were always present on all days. On the last day, my lord.
All present only for the taking adjournment.
No. We had started the matter, lordship. We have placed the judgment from the compilation. kindly recollect, my lord, Lordship, kindly come to the compilation of judgment which was handed over.
Yes.
Matlab, the point we were arguing, matlab, in the plaint, matlab, their specific performance, matlab, they are seeking specific performance of only 3 clauses of the development agreement.
Yes.
Matlab, so on the point of section 12 of the specific relief act, matlab, the part performance of the agreement was claimed, and on basis of that, matlab, we are submitting the suit is not maintainable. Now
Correct.
kindly come to the compilation of judgments, matlab, the hard copy of which was handed over.
Yes.
Mr. Last judgment, which Mr. Mitra had placed, if I'm not wrong, that was the AIR 212 1 SCC page 656. That is at page 25 of the compilation.
Yes.
This was the Suraj land judgment which has also been noticed by your lordship in lordship another order.
Yeah,
Here,
that
yes,
Mr. Mitra
yes.
already argued on this.
Yes, paragraph 20, which was kindly come to paragraph 20 of this.
Yes, I have taken note of that, already argued.
Yes, madam. That
Already pointed out that.
yeah, kindly come to the next judgment, my lord, which is at page 38 of the compilation. This is 2019 SCC online Bombay.
That is also pointed out.
Para-
Paragraph 13.
para
Relied
13.
Suraj Lamb.
Yes, madam.
Paragraph 13.
I'm
relied
extremely grateful.
Yes, then.
Then, my lord, next one is the AII 64 Supreme Court, page 11, para 39.
Para 39.
39.
Yes. That is also.
No, I don't. This was I'm in my noting, madam, it has not been cited. I may be wrong, madam, what I noted that day.
I have noted, already pointed out. Para 39.
Lordship have noted. I may have missed it.
All judgments have already been pointed out by Mr. Mitra. I have taken note of all this.
Kindly then, just give me 1 moment.
The other judgment also he has pointed out, Mr. Mitra has already pointed out AI 1981, paragraph 17.
Yes, ma'am. That is on the point that no court will pass a futile writ. Because if the power attorney, madam, what they're asking, madam, I have the authority to revoke on the very next day. So that is the issue, madam. The next judgment in this was the SM Amarchand versus Tamil Nadu electricity matter. Madam, this is Manu TN 0034 of 1999, paragraph 20.
Yes. That is also paragraph 20. I have taken note of.
Yes, correct. Absolutely. I'm extremely grateful. Malo, on the next proposition is Malo, decree for mandatory injunction which is claimed in the suit cannot be granted in lieu of specific performance.
Correct.
Malo, on this proposition, Malo, like kindly come to the compilation AIR 2017 Supreme Court 5239.
5329. Yes.
5 paragraph 18. If my lordship kindly allow me to place that.
Yes, paragraph 18.
Give me just 1 moment. I'm on the soft copy. Just give me 1 moment, lordship. That is at page 79 of the compilation.
79, no, 81.
Yes, my lord.
Yes.
Starts at page 17. Oh, I'm 81. Lordship is correct, my lord. Page 80.
That is a limitation.
Yes, my lord, mandate. Because, my lord, lordship kindly recollect, my lord, here they have quantified the amount which they have claimed in the suit. If lordship sees the plaint, my lord, here they have quantified the amount of damages.
Correct.
Lordships come to IAGA 2, my lord, the amount of 55. What is my lord? Give me 1 moment. Lordships kindly come to this application, where they have quantified the amount of damages which they have suffered. That is at page 5, my lord, of the application, page 5, subparagraph B, the plaint case we have quoted. Page 5, paragraph capital B.
Yes.
The plaint case is that plaintiff has already suffered loss and damage to the extent of 5,70, 33, 888 plus security deposit of rupees 5 crore as most fully mentioned in paragraph 11 of the plaint. So on this, once they have claimed the exact quantified amount which we have already said we are willing to put it in court. We are willing to offer that put it in court so that the injunction which we are suffering can be vacated. On this proposition, this judgment we have shown that degree for mandatory claim cannot be granted in your specific performance. That is AI 2017 Supreme Court 5239 paragraph 18.
Yes.
And on the next proposition, the extent of loss which the plaintiff will suffer is already been assessed in details, which I have just placed. So therefore, his compensation will give adequate relief. Then mandatory injunction cannot be granted. Kindly take the specific relief act, section 14, subsection 3. C.
Yes.
Can you come to section 14? The following contracts cannot be specifically enforced.
Yes.
The contract, the performance of which involves the performance of a continuous duty which the court cannot supervise. Here, they are asking for the execution of the power of attorney for the purpose of enabling the development work to be carried out, which requires continuous supervision of court, which is not possible. And the prayers in the suit to such extent, are misconceived. On this proposition, kindly come to the citation, which we have enclosed is 2006 Patna, page 91, that is at page 84 of the compilation. Paragraph is 48 to paragraph, 1 second. Paragraph is at page at the running page. Lordship, give me 1 moment. It starts at page 91.
Yes.
Your Lordship has the entire judgment in my compilation, but the remaining pages are missing. Page 91. I don't know whether Lordship's brief, the entire judgment is there.
91 is the last one.
In my copy, it's in the full judgment is not there in the hard copy. Lordship has the entire, complete judgment.
Yes.
In my compilation, the entire set is not there.
What is the name of the parties?
My name of the party is
IPB's company.
1 second, Lordship.
Page 84.
Yes, I found it. It was wrong page number was given. Yes, sir. Lordship is absolutely correct. Lordship, here comes to paragraph 22. I'm grateful. Kindly come to paragraph 22.
Yes.
From the perusal of section 10 of the Act, it appears that section 10 lays down principles where specific performance of the contract can be enforced, whereas section 14 lays down the principle where contracts cannot be specifically enforced. Section 14A says that a contract for non-performance of which compensation is an adequate relief cannot be specifically enforced, whereas section 14(1)(c) says that a contract which is in its nature determinable can also not be specifically enforced. According to the submission of learned advocate of the appellants, the case of the plaintiff is that as a result of non-performance of the contract, refusal to grant dealership by the defendants, the plaintiff has suffered loss of rupees 1 lakh due to purchase of land as well as bricks. The learned advocate further submitted this averment in the plaint itself shows that the loss suffered by the plaintiff was ascertainable, for which the plaintiff was entitled to bring a suit for compensation. And as such, the provision of section 14(1)(a) of the Act, which I just placed, the suit of such type of contract is barred.
Yes.
Now, lastly, my lord, the last proposition is, my lord, the court today, what my learned friend are seeking is calling upon the court to bring into existence a contract between the parties by seeking an order of decree of mandatory injunction to seek a direction upon me to execute a power of attorney, which is not permissible. For that, my lord, kindly come to the, this judgment. Unfortunately, but this is not in the compilation. 2024 4 SCC. Mala, there are 3 new judgments, mala, which are not in the compilation.
Yes.
Mala, if my advocate on record is there, Mr. Balodia, if you can hand over 2024 4 SCC, page 230. Mala, this is a new judgment which is not in the compilation. If you can hand over if my advocate on record can hand over the hard copy of 2024 4 SCC 230.
Advocate on record is handicapped. He is not having anything. I think he is not having the brief also.
Oh. Lordship, will kindly allow me to come on Monday. Only 3 judgments and then this, and we will finish, my lord. This is the last head of the arguments, my lord.
Mr. Sharma, could you please give us a copy of, or at least indicate the
Yes,
3
yes.
judgments that you wish to sign?
Yes, I will just tell you.
If then Lordship can kindly keep it on
Monday, my lord. The next working day is Monday.
Suffering for the plaintiff, sensation suffering for the defendant. Counsel for the plaintiff, counsel for the defendant has argued the matter, but the argument could not be completed and he prays for time. According cases adjourned that the matter appear on
21st is Monday.
no, not Monday. Monday I am having the
Oh,
20
so 20.
Grateful, Lordship.
Lordship is said 23rd.
Yes.
My lord, instead of 23rd, my lord, can it be 23rd and 24th? I'm in some difficulty. Then Lordship, can it be on 29th to 28th, Monday?
28th. 28th.
Grateful.
Yes, next.
My lord, I am for the plaintiff respondent, my lord. But Mr. Shodhadip Bhattacharya was making his submissions under Order 9, Rule 13, my lord. He has not completed, my lord.
So where is Mr. Banerjee? Bhattacharya.
I really don't.
Order 9, Rule 13.
Yes, my lord. Order 9, Rule 13 decree has been passed by your lordship. After, my lord, it was published, my lord, in the newspapers, my lord.
Okay.
So that was the provision, my lord.
Sensation suffering for the plaintiff, none appears on behalf of the defendant. For the interest of justice, the case is adjourned. Let the matter appear on 29th April.
My lord, could it be 30th, my lord, 29th, my lord? I'm sorry, my lord,
30th April.
But I got a chance to teach in one of the universities, so I'm leaving for that, my lord. So that's why.
Good.
Very grateful, man.
Item number 48. This is my application under Order 7, Rule 11. On the last occasion, Mr. Sahu is leading me in this matter. Mr. Debraj Sahu happens to lead me in this matter. The limited conspectus was that a settlement agreement that cannot form the subject matter of a commercial dispute as per Section 2(1)(c). Lordship, we had heard he had placed the matter. He had cited the 2 judgments of HON'BLE Sarabai and a judgment of your lordship. They were, my learned friends from the other side were supposed to come up on the limited conspectus that this falls within the definition under 2C. So they are not here today, of course.
Who is there? Who is the other side?
Mr. Niloy Sengupta, I'm instructed.
Sensation suffering for the defendant, none appears on behalf of the plaintiff. For the interest of justice, case is adjourned. Let the matter appear on 2nd May.
Second.
Next.
Grateful to you.
Otherwise,
Lordship, with your kind leave, before the fixed matter is taken up, Lordship, item number, Lordship, I was on my legs, Lordship.
Madam, when you find the time, you persons are started mentioning since morning. When the matter is called, you all persons will be away from the court.
Lordship, I
when I was
understand that, Lordship. I had mentioned
raising
it
from the
before
chair,
had
you
raised-
mentioned the matter. I told you come at 2.
I had a fixed matter, Lordship. I was on my legs.
What
I
cannot
didn't
sit?
realize the fixed matter had
The
been
matter,
had.
June. I
Lordship,
already
kindly, Lordship.
Sorry, madam, sorry. Yes, call the fixed matter. Who is for the
I appear for the plaintiff. My lord.
Yes.
This matter was appeared. My lord,
Witness
it's
present?
proceeding ex parte. Yes, my lord. Witnesses is here. We've brought, my lord, the affidavit of evidence. May I file the affidavit of evidence?
पहली बार गवाही दे रहे हैं या आगे भी
आगे भी दिए।
व्हाट इज आपका नाम?
श्याम सुंदर मंत्री।
स्पेलिंग
SHYAM
YAM
SUNDER
UNDER
MANTRI।
MANTRI.
The first time?
My lord, first time. It's the chief, my lord. Chief. No, the witness, my lord, this is the first time. My lord. He's deposed before.
No, this
My lord is asking whether this is the first witness of the plaintiff. Yes.
first witness.
First witness.
No, earlier he was examined in the matter.
No.
No.
First time.
That
First
day,
time.
na?
Today is the first time.
Because he came on the other matter. Sir.
In another matter, my lord. Similar matter, my lord, had already been.
इस मैटर में
Yes.
मेरे साथ बोलिए, ठीक है? मैं कसम खाता हूँ
मैं कसम खाता हूँ
जो कुछ बयान दूंगा
जो कुछ बयान दूंगा
वो सच होगा,
वो सच होगा,
मेरे बयान में कुछ झूठ नहीं होगा,
मेरे बयान में कुछ झूठ नहीं होगा,
ईश्वर मेरी सहायता करेंगे।
ईश्वर मेरी सहायता करेंगे।
आपका नाम?
श्याम सुंदर मंत्री।
पिताजी का नाम?
लेट मन्नालाल मंत्री। मन्नालाल MANNALLMNTRI।
आपकी उम्र?
59।
क्या करते हैं आप?
कंपनी में काम करता हूँ, प्लेंटिव कंपनी में।
आपका घर का पता बताइए।
ऑफिस का जो इसमें 261 लेक टाउन ब्लॉक बी फॉर बॉम्बे, कोलकाता 89।
यस सर।
Mr. Mantri, I am showing you a document. Kindly tell my lord what this document is.
डॉक्यूमेंट को देखिए और माय लॉर्ड को बोलिए ये डॉक्यूमेंट किस बारे में है और क्या है।
माय लॉर्ड, ये मेरा एफिडेविट ऑफ एविडेंस है।
दिस इज माय एफिडेविट ऑफ एविडेंस।
Who has prepared this document?
इस डॉक्यूमेंट को किसने प्रस्तुत किया है, तैयार किसने किया है?
ये मेरे इंस्ट्रक्शन पे मेरे लर्नड एडवोकेट ने।
This document was prepared by my learned advocate under my instruction.
Whose signature do you find at page 18 of this affidavit?
Affidavit की पेज 18 में किसका सिग्नेचर है?
मेरा सिग्नेचर है ये।
This is my signature appearing at page number 18 of the document.
What do you have to say of the contents of this document?
डॉक्यूमेंट के कंटेंट्स के बारे में आपका कुछ क्या कहना है?
ट्रू एंड करेक्ट है सर।
The contents of the documents are true and correct.
Lord, I'll just proceed with exhibiting because everything is there. I'm showing you this original document.
Chief
Kindly tell this this honorable court. Kindly tell my lord what this document is.
ये डॉक्यूमेंट क्या है, माय लॉर्ड को बोलिए।
ये जो ओरिजिनल डॉक्यूमेंट सबमिट किए हुए हैं 14th जुडिशियल मजिस्ट्रेट कलकत्ता में, उसकी सर्टिफाइड कॉपीज का पूरा सेट है सर।
This is the complete set of the certified copy of the document which has been submitted.
These are the certified copy of the document which I have filed before the which court?
14th Judicial Magistrate, Kolkata.
May I just open the document and show him one by one, because or else it's not paginated.
আচ্ছা
সেলাইটা করবে correct. Shown document corresponding to pages 87 to 92 of the judge's brief of documents. Kindly tell my lord what this document is.
ये कंप्लेंट पिटीशन है जो 14 जुडिशियल मजिस्ट्रेट में फाइल किए थे.
This is the complete complaint petition which was filed in the 14th Judicial Magistrate. It's filed at 14th Judicial Magistrate.
Lord, I apologize, judge's brief wasn't filed. Either way, copy ठीक है. My lord, I'll file an additional copy if it's not filed. Who has filed this complaint petition?
इसने ये complaint petition फाइल किया है.
ये हमारे कंपनी के उस टाइम के जनरल मैनेजर मिस्टर जादूमणि साहू उन्होंने फाइल किया था.
This complaint petition was filed by the then general manager of our company, namely Mr.
जादूमणि साहू.
Jadumani Shahu.
Where is Mr. Sahu today?
Mr. Shahu अब कहाँ पर है?
He has expired.
He has expired.
What do you say of the contents of this complaint petition?
Complaint petition के contents के बारे में आपका क्या राय है?
True and correct है.
True and correct.
Let me I mark this complaint petition my lord, as exhibit 1.
A certified copy?
My lord, original certified copy of the entire case record.
Exhibit 1.
Yes.
Exhibit
A.
Exhibit A.
Mr. Mantri, I'm showing you a bunch of documents corresponding to pages 29 to 69 of the judge's brief of documents. Kindly tell my lord what these documents are.
ये document क्या है? My lord को बोलिए.
My lord, ये टैक्स इनवॉइस की कॉपीज है
These are the copies of the tax invoices
जो कि हमने रेज किया था टू द डिफेंडेंट
which were raised by us to the defendants
अपॉन सेल ऑफ मटेरियल्स.
upon the selling of the materials.
Where are the originals of these documents?
The invoices का original कहाँ पर है?
ओरिजिनल तो डिफेंडेंट के पास में है ये,
The originals of the invoices are with the defendants.
और ये सर्टिफाइड कॉपीज है जो हमारी ऑफिस कॉपी है उसकी सर्टिफाइड कॉपी है.
These are the certified copies of our office copies.
What do you say of the contents of these documents?
इस document के contents के बारे में आपका क्या ख्याल है?
ट्रू एंड करेक्ट है सर.
True and correct.
Let may these be marked collectively, my lord, as
Exhibit B
exhibit B.
collectively.
29 to 69 of judges.
Yes, next.
Mr. Mantri, I'm showing you documents corresponding to pages 70 to 83 of the judge's brief of documents. Kindly tell my lord what these documents are.
ये document क्या है? My lord को बोलिए.
माय लॉर्ड, ये डिलीवरी चालान की कॉपीज है.
These are the copies of the delivery challans.
Where are the originals of these delivery challans?
इन delivery challans का original कहाँ पर है?
ये जो डिफेंडेंट ने साइन किया, एक्नॉलेज किया, इसकी ओरिजिनल कॉपी हमारे 14 जेएम में जुडिशियल मजिस्ट्रेट में सबमिट है.
The originals of this delivery challenge have been submitted to the 14th Judicial Magistrate Court after it was signed by the defendants.
Kindly encircle in reading the signature of the defendant in the document corresponding to page 70 of the judge's brief of documents.
Ready.
First thing যেটা আমি খুলেছি ওটাই page 70.
डिफेंडेंट एक्नॉलेज.
Encircle कीजिए reading से. The witness encircled the signature of.
Well, there's several similar. One of them have been encircled. Well, I'm not doing this. That's already pleaded in the affidavit. Sorry. Excellent. What do you say of the contents of these documents?
इस document के contents के बारे में आपका क्या कहना है?
They are true and correct, sir.
My lord, may they be marked as exhibit?
Exhibit C collectively.
Collectively, my lord, collectively. Correct.
One second.
So once again, I'm showing you a document corresponding to page 84 and 85 of the judge's brief of documents. Kindly tell my lord what this document is.
ये document क्या है, my lord को बोलिए.
My lord, ये चेक का कॉपी है जो डिफेंडेंट ने हमको दिया था.
This is the copy of the check which was given to us by the defendant.
Where is the original of this document?
इस document का original कहाँ पर है?
इस चेक का ओरिजिनल जो 14 जुडिशियल मजिस्ट्रेट में सबमिट किया हुआ है.
Original of this document have been submitted to 14 Judicial Magistrate Court.
What do you say of the contents of this document?
Document के contents के बारे में आपका क्या ख्याल है?
These are true and correct.
What happened to the check? Sorry. Did the plaintiff present this check for payment? Present this check for payment.
Plaintiff ने क्या check को present किया है?
हाँ, we have deposited in our bank account.
Yes, we have deposited the check in our bank account.
What happened then?
उसके बाद क्या हुआ?
It was dishonored.
The check got dishonored.
For what reason was this check dishonored according to you?
किस कारण के चलते ये check dishonor हुआ आपका?
The reason was the funds insufficient in the account of the defendant.
The check got dishonored due to insufficient balance in the account of the.
Okay. I'm showing you a document appearing at page corresponding to page 86 of the judge's brief of documents. Kindly tell my lord what this document is.
ये document क्या है, my lord को बोलिए.
My lord, ये रिटर्न मेमो है बैंक से जो हमने चेक डिपॉजिट किया, उसके साथ में बैंक ने रिटर्न मेमो दिया हम लोगों को.
This is a check return memo issued by the bank along with the check.
Where is the original of this return memo?
इस document का original कहाँ पर है?
इसका ओरिजिनल 14 जुडिशियल मजिस्ट्रेट में सबमिट किया हुआ है.
The original of this document has been submitted to 14 Judicial Magistrate Court.
What do you say of the contents of this document?
इस document के contents के बारे में आपका क्या ख्याल है?
These are true and correct.
My lord, may the check along with the return memo collectively, my lord, as exhibit D.
It be collective.
D collective. I correct to the
हाँ.
Yes, next.
Mr. Mantri, I am showing you a document. Kindly tell my lord what this document is.
ये डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए.
ये मेरा एविडेंस इन चीफ जो है 14th जुडिशियल मजिस्ट्रेट में एफिडेविट फाइल किए थे, उसका कॉपी है.
This is the copy of the
एफिडेविट
this is the affidavit of the evidence
In chief.
which was filed by me in the
14th जुडिशियल मजिस्ट्रेट.
14th Judicial Magistrate Court.
What do you say of the contents of this document?
इस डॉक्यूमेंट के कंटेंट्स के बारे में आपका क्या राय है?
ये ट्रू एंड करेक्ट.
It's a part of the certified copy. Malad, this is a part of the certified copy in total, since it's a bunch. It appears true and correct. Malad, may this also be marked as exhibit? Malad, E.
E. Exhibit E.
The judge's brief take together.
Page number 81. Yes.
Mr. Mantri, I'm showing you pages 1 to 28 of the judge's brief of documents. Kindly tell my lord what these documents are.
पेज नंबर 1 to 28 देखिए और माय लॉर्ड को बोलिए ये डॉक्यूमेंट क्या है.
माय लॉर्ड, ये लेजर अकाउंट की कॉपीज है जो हमारे बुक्स में हम लोग मेंटेन करते हैं.
This is the copy of the ledger account
ऑफ सामंता एंटरप्राइजेस प्रोप्राइटर छवि सामंता,
which was maintained by us in our accounts book.
अकाउंट्स बुक कंप्यूटर सिस्टम.
In respect of the defendant, Chobi Samanto,
Namely, Samantha.
छवि सामंता.
Chabi Samantha.
Yes.
does the plaintiff maintain its ledger account in a physical form or in digital form?
आप लोग क्या फिजिकल फॉर्म में मेंटेन करते थे या डिजिटल फॉर्म में ये लेजर मेंटेन?
डिजिटल फॉर्म में.
इन डिजिटल फॉर्म फॉर्मेट.
What do you say of the contents of these documents?
इस डॉक्यूमेंट के कंटेंट्स के बारे में आपका क्या राय है?
These are the true and correct.
True and correct.
Lord, may these are printouts. Lord, may they be marked as exhibit F. Plain tag ba dekha, plain tag dekha.
1 to 28.
Well, Mr. Mantri, could you tell my lord what this document is?
डॉक्यूमेंट क्या है माय लॉर्ड को बोलिए.
माय लॉर्ड, ये मेरा प्लेंट की कॉपी है जो हमने फाइल किया कोर्ट में.
This is the copy of the plaint which was filed by us in the court.
Who has affirmed and verified this plaint?
प्लेंट को affirm और verify किसने किया है?
मैंने अफर्म किया.
The plaint was affirmed by me.
What do you say of the contents of this document?
डॉक्यूमेंट के कंटेंट्स के बारे में आपका क्या ख्याल है?
The true and correct.
True and correct.
Mr. Mantri, why has the plaintiff filed the present suit?
प्लेंटिफ ने ये मामला क्यों किया है प्रेजेंट?
For recovery of the money for against the amount due from the defendant.
For recovery of money and getting the due amount from the
That's all.
defendant.
That's all. Well, the entire certified copy, all the documents are exhibited. Well, I'll ask one last question. Well, I'll mark the entire certified copy also, since this is certified copy. No, that's true. Well,
Not
that's
necessary.
not
It's a
necessary.
certified copy.
Right.
Is
Obliged.
the document necessary already marked?
Yes, it's already obliged.
Yes, record. Any further witness?
No, but
Offenses and suffering for the plaintiff. Plaintiff witness is present. During his examination, document were marked as exhibit A to exhibit
F.
F. Correct. F. Full stop. Plaintiff evidence is closed. Full stop. Counsel for the plaintiff submitted. He will not adduce any further evidence. Close and discharge. And the witness is discharged. Counsel for the plaintiff submitted. He will not adduce any evidence. Accordingly, evidence on behalf of the plaintiff is closed. Fix the matter for argument on when?
not whichever day, Manoj, we can keep it on
vacation.
Monday. And keep it on Monday, Manoj. It's a 5-minute matter, Manoj. We won't take much time.
Let the argument on 28th.
28 April, my lord. Obliged.
That's all. Next.
Milords, in item 49 appear for the plaintiff, Milords. Milords, GACOM 3 is my application seeking an amendment of the plaint, Milords.
Amendment of the plaint.
Yes, Milords.
Who is for the defendant?
Milords, no one is appearing for the defendant,
Not
Milords.
served.
Milords, not served, Milords.
Why? When the plaint was admitted?
Milords, it was admitted on 12th of July 2024.
Writ of summons was not lodged.
No, Milords. Thereafter, Milords, there had been several defects that we have cured, and for certain defects to cure, amendment of the plaint was required and leave of court was required, Milords. So after taking leave of this court, Milords, we have filed this instant application, Milords.
Where is the amendment?
Milords, amendment is at annexure number C, Milords, page number 10.
Page 10.
Milords, and the list of amendment is given at page number 3, para 4. The amendments that we have carried out.
1865. Plaint admitted?
Plaint has been admitted, Milords.
Only the year and all these things.
Milords, there had been certain elementary mistakes, Milords, which we have rectified, Milords. Milords, the jurisdictional issue inside and outside the jurisdiction, Milords.
Sensation suffering for the plaintiff. Sensation suffering for the defendant. Plaintiff has filed an application being GACOM 3 of 2025, praying for amendment in the plaint. Had the learned counsel for the plaintiff peruse the proposed amendment, this court find that the amendment as sought for by the plaintiff will not change the nature and character of the suit. Accordingly, and is formal in nature. Accordingly, prayer A to C. No, A and B. A and B of the master summon is allowed. GACOM 3 of 2025 is disposed of.
Obliged, Milords.
Next.
My lord, in this matter, we are on behalf of the defendant. My lord, in this matter, Mr. Shubhankar Nak appearing in this matter. My lord, he's on his leg. My lord, kindly keep it.
You are not in. You are not in your leg.
My lord, not just brief to my lord. It's very complicated matter, my lord.
Complicated matter.
I am assisting Mr. Nag, but since he is not there, my lord, your lordship. But I would have prayed for a similar order as the one previous. Just that I'm for the defendant, I'm wanting my amendment application to be allowed.
Which one?
This one, item 50.
This
But
one?
since, yes.
You are
It's
for
the defendant's application for amendment of a written statement.
Oh, amendment in the written statement.
Written statement.
You are for the plaintiff.
No, defendant, my lord.
Who is for the plaintiff?
My lord,
Plaintiff is not here, Mr. Gupta.
Very well.
Not today.
Obliged, my lord.
Great.
Next.
My lord, item number 51, I'm appearing on behalf of the decree holder, my lord. On the last occasion, the arrest warrant was recalled. My lord, now the parties have entered into talks of settlement, my lord. My lord would kindly adjourn the matter to another date.
So suffering for the execution.
Yes, my lord, it's an execution petition.
You are for the decree holder.
Yes, my lord.
So appearing for the degree holder. Will the counsel for the degree holder submit that talk of settlement with the parties going on and pays for adjournment. In view of the submission made by the counsel for the degree holder, case is adjourned. Let the matter appear. When? After vacation? Let the
As your lordship deems fit.
matter appear on 10th June 2025. Next.
Obliged. Grateful, my lord.
My lord, I'm for the defendant. The grandmother of arguing counsel passed away, and today is her Shraddh ceremony.
As per the prayer made by the counsel for the defendant,
Adjourn the matter.
the case is adjourned. Let the matter appear on 22nd May. Next.
53 milad is that matter where Mr. Drolia is arguing. Milad, it was fixed last on 10th of
Monday, na?
It is fixed last on 10th. Milad is fixed on Monday at 2 p.m. Let it happen, Milad, on Monday and Tuesday, Milad. It's
already fixed.
It's already fixed.
Come on.
Number 54.
Who is appearing? Nobody. None appears on behalf of either parties. In terms of the order passed by this court dated 6th March 2025, the London Registrar of Original Side has filed the report. Let the same be kept with the record. Release the matter on 11th June. Next.
That item 55. I'm led by Mr. Gupta. My lord, this is a matter your lordship will take the last order 6th of March 2025.
Sixth of March.
Yes.
That the suit be restored in original
Mr.
file
Gupta
and
is
number
there on
along
that.
with the pending application if and subject to payment of to the High Court Legal Service Committee.
This was restored on this date, my lord.
Restored.
My lord, there are, and we have deposited the amount, my lord.
So
as
what
per
is the
law.
stage of the suit now?
My lord, defendant number 2 has entered appearance. Defendant number 1 is a UK-based company, went into liquidation. We have substituted the names of the official liquidators in UK. My lord, service has to be checked, my lord, on the defendant number 1. Service of the writ of summons, my lord. My lord, there are other 2 suits of different plaintiffs with regard to the same defendant. Those are appearing on 1st of May. I was humbly beseeching your lordship if this matter also, since it was restored lately.
Possibly a report needs to be called for from the department with regard to the service. Then, if it is served, then we can pray for it to be marked as undefendant so far as the defendant number 1 is.
You have to apply for the report, sir.
We have applied for, I think the report is there already, but
I think Mr. Gupta is talking about the other matters. I don't think that those orders have been passed in this suit.
Nothing.
Because it was
restored on last date. So suffering for the plaintiff. Police counsel for the plaintiff submitted that the connected matter is fixed on 1st of May 2025. Let the matter appear on 1st May 2025. Along with the other 2 matters.
Yes, connect. Very good.
Your Lordship,
Before your Lordship rises, my lord, this is something, my lord, kindly pardon me. I'm mentioning a matter, my lord. This is item 33 of today's list. Your Lordship has taken up the matter. Your Lordship has posted the matter for
16th of May. My lord, I am mentioning upon notice to all the parties, my learned advocate on record is in court. My lord, for personal difficulty, I had to leave the court. My lord, the only prayer is an innocuous prayer. In this list, my lord, there is an application GA8. My lord, that's for substitution. My lord, this is with relation to that partnership firm and issues relating to the partnership firm. My only prayer is, my lord, GA8 be made not today, and my lord, may it come in the list on, my lord, Monday. My lord, there is
somebody has appeared in the matter. That's
my lord, they appeared, they could not, my lord, indicate the fact. I'll indicate, my lord, what has transpired here. There are connected appeals which are, my lord, being taken up by the division bench of the court. And my lord, there we could not proceed because, my lord, the substitution is pending. My lord, there's an extreme urgency. It should have been pointed out, my lord. It is our fault. We could not point it out to the honorable court.
Mr. Bagh, that is the
My lord.
problem.
I know, my lord.
Once the matter is listed, nobody will appear. When the matter, the
understand,
court
my lord.
pass an order fixing the date, now you all persons are starting mentioning either morning, either lunch time, or at the time of rising.
I apologize, my lord.
I am stopping all this practice. If anybody appear, okay, not appear, I am fixing after 2 months.
I apologize, my lord. This is something we
Every
should
matter. Since 2 p.m., none has appeared. Once I have
I-
dismissed the 2-3 suits, all started coming.
I apologize, my lord. I understand that. It's an extreme difficult
And
situation.
in this matter, some advocate has appeared. Nobody has mentioned this, and then I have fixed the matter on 16. On the ground
I
senior.
apologize, my lord. It is something which we should have mentioned. My lord, may I only pray for this?
Henceforth, I will not take any of the mentioning matter.
I apologize, my lord. This is completely. I beseech your lordship, my lord. But I'm only praying for this. GA8, rest of the matters may be listed for 16th of May.
No,
My lord,
no.
GA8.
This court, if the matter is there, all the application, all suit has to be bring
I'm
on
very-
record. Not one application is to be in this that
I understand.
that day.
I understand. My lord, kindly make it not today. My lord, let it come back on Monday. And my lord, we'll also give a notice immediately. It's item 33, my lord. Item 33, my lord.
36.
It's 33, my lord. 33.
33, not today, girl.
And we'll inform all the parties, my lord. I'm very deeply obliged, my lord. Very deeply obliged.
Item number 2, my lord, I was
same thing.
My lord, kindly
Morning
consider.
you mentioned.
My lord, I was running. My lord, was just fall down outside the court.
I find you were sitting
My
here
lord,
when the other case was going on.
My other case, my lord, I was run to court number 9. While my lord, returning back, my lord, I fall down. My lord, just my lord, I'm tendering my apology. Kindly consider, my lord.
When you will be available, when your witness will be available.
My lord, 2 weeks, my lord.
Record item number 2. Earlier order was passed and dismissed for default. That is to be recalled. So and so appearing for the plaintiff. The matter is fixed today for witness action, but due to some personal difficulties of the advocate of the plaintiff, it is not possible for the plaintiff to adduce the witness today. Accordingly, pays for adjournment. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter give the date 14th July at 2 p.m.
Yeah.